We have another witness. Is that correct, Ms. Zungu?
Yes, Chair, that is correct.
Yes. Would you introduce your witness and I will swear him in?
Thank you, Chair. The witness that is before us today is Mr. Fani Dingiswayo.
Yes, thank you. Mr. Dingiswayo, do you have any objections to taking the prescribed oath?
No.
Well, would you, as they say, raise your right hand and swear that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth? Say so help me God.
So help me God.
The witness have been sworn in. Thank you.
Thank you, Chair. For leading the evidence of Mr. Dingiswayo, I just thought I just need to make it easier for the panel and for everyone here, is that I'll be referring to Volume 7, Volume 8, Volume 20, and Volume 16.1. At least then we have the bundles easily before us already. Volume 7, 8, 20, and 16.1. Thank you, Chair. Thank you, Chair. Mr. Dingiswayo, are you still employed at PRASA?
No, Chair. I left PRASA at the end of January, I think 2020.
And when were you employed at PRASA? Can you give us the timeline when you were employed at PRASA?
I was employed at PRASA, Chair, from the 2nd of September 2013 to the end of January 2020.
While you were at PRASA, what position or positions did you hold, and when was this?
I just held one. I was the General Manager, Group Legal Services.
I'm sorry, could you just speak up a bit?
Apologies, Chair.
Yes.
I was the General Manager.
I just want to recap. You were employed from 2018.
2013.
Oh, 13.
1-3.
Yes. To 2020.
Correct.
And what were you employed as?
A General Manager, Group Legal Services.
Yes, thank you.
Thank you, Chair. And who did you report to?
I reported to Ms. Mathangoye.
The position of Group Legal Services, what did it encompass? What were your duties and functions?
Chairperson, I was responsible for the legal department. The legal department had about 6 lawyers that were working and reporting to me. So the team provided legal advice to the group. We instructed outside lawyers where there's a need to instruct outside lawyers. So in terms of the legal advice, I mean, it would be various things. Either just giving opinions or assisting with policies, drafting of policies. So that was mainly the internal work that we do. In terms of interfacing with outside lawyers, we would be the conduit for all communications between our internal clients. And when I'm saying internal clients, I'm talking the CEOs of the various divisions of PRASA, the CEOs of the 2 subsidiaries of PRASA, that is Autopex and Intersight. And we also had departments. So the group executives in those departments were our internal clients. So we would be the go-between between, did I say 2 betweens? The internal client and the outside lawyer.
Being the general manager for the group legal services, do you hold a law degree or a legal degree? And if so, what degrees do you have or degree do you have?
I have an old degree, Chair, which was called BProc. I believe it was discontinued. And a higher diploma in company law. I am an admitted attorney. I was admitted in 1999.
Mr. Dingiswayo, is it correct that you submitted an affidavit for the purposes of the Zondo Commission?
That is correct.
I want to
Chair.
refer you to volume 20.
Yes, I have volume 20, Chair.
Please, can you open it to page 3?
Chair, my copy has page 1, 2, and 4.
What do you mean, 1, 2, and 4?
You say you don't have page 3.
Correct, Chair.
Can we find page 3 for the witness?
I have page 3.
Thank you. Your affidavit, is it correct that your affidavit begins at page 3 of that bundle?
Yes, page 3 to page 28.
Yes. On page 28, did you sign that affidavit?
That is correct. I signed the affidavit in front of a Commissioner of Oaths.
And the commission, and you commissioned that document on the 18th of February 2020?
That is correct.
Thank you. This affidavit that I've provided to, or that has been placed before you, is it correct that it deals with the CIA issues or the CIA matters?
Yes, yes, Chair. That's one of the matters that we covered at the Commission of Inquiry.
Okay. I'm not going to deal with all the other issues that are from page 3 up until the top of page 18, but I would like to refer you to page 18.
I am at page 18, Chair.
It is noticed in the, well, top part of the affidavit, it's written the CIA group, you note that.
Yes.
Who owned CIA?
Chair, from our knowledge, there was a number of companies called CIA. There was CIA Consulting Engineers. I think there was something called CIA Engineers. There was CIA Fuel. And then there was CIA DB. And I'm not certain, I think CIA DB and CIA Consulting Engineers was the same company. All those companies were owned by a man called Makensa Mabunda.
And these companies that you've just referred to, did they provide, were they service providers for PRASA?
Chair, the CIA group of companies formed one of the most fortunate providers of services to PRASA.
Why do you say most fortunate?
Chair, after the public protector issued her report entitled Derailed, one of the recommendations was to look into contracts that were issued between 2012 and 2015. And the CIA companies had contracts worth around $1 billion. Mr. Mabunda is also understood to be the brains behind the 3.5 billion locomotives contract that was awarded by PRASA. So Mr. Mabunda is someone who was very fortunate when it comes to PRASA. We had understood that, well, it's public knowledge that he worked with Mr. Montana at the Department of Transport, Mr. Montana, who was the CEO of PRASA. He worked with him at the Department of Transport. Mr. Montana left the Department of Transport and went to the Department of Public Enterprises. Sorry, I'm mixing my facts. He worked with Mr. Montana at the Department of Public Enterprises. And Mr. Montana moved to the Department of Transport and was a DDG in charge of public transport. In that capacity, one of the projects Mr. Montana was doing was the taxi recapitalization project. Mr. Mabunda was a service provider to the Department of Transport in that project of taxi recapitalization. And when Mr. Montana left the Department of Transport, he came to PRASA, and Mr. Mabunda and his companies got contracts from PRASA.
Have you ever met Mr. Mabunda at the time when you were at PRASA, like engaged with him?
No, Chair, I have not had the pleasure to meet him.
Did you testify at the Zondo Commission? Sorry, did you testify at the Zondo Commission?
Correct?
Now, before we get to the details of your affidavit, we need to understand this. Maybe you can outline the process for the tribunal. You've indicated that you were the conduit between your internal clients and the external firms. When summons was served at PRASA for any business units within PRASA, what process was followed so that we can understand the process that is followed when there are any legal documents that are served in PRASA? What process would be followed?
Chairperson, we had established a good relationship with two sheriffs that serve normally at PRASA. So PRASA had a corporate office in Hatfield and another office in Braamfontein. So we knew the sheriffs that served there. So the arrangement that we had with them in Hatfield is that when a summons comes, they were allowed into the building to come to the third floor in the legal department and give those summonses to a lady who was an administrator of the legal department. This lady would then look at the summons and register them, as an administrative action, and then from there, she would bring them to me. I would read the summons to check which division or department was the end user in relation to whatever claim is made, and I would then make contact with two people. So as I said, we had 6 people reporting to me. We divided all of them, so all of them had clients. So you had one person servicing a division of PRASA called PRASA Tech. So if, for example, these summonses, I think 3 of them related to the business of PRASA Tech. So I would then give the summonses to the lady who was servicing PRASA Tech, lady by the name of Shumi Mukotedi, so that she can then interface with headlines. The preliminary interface is to check whether there is a defense or the matters should be defended. Because in the High Court, you have 10 days, or I think even in the Magistrates Court, you have 10 days to enter an appearance to defend. And what we tried to do is not to incur legal costs unnecessarily. So the preliminary assessment, is there defense, or is this invoice just late? There was a problem in processing it. If it's just late, we ourselves would make contact with the plaintiff's attorneys and try to get some indulgence and get it settled that way. If there is a defense, then we appoint lawyers. They enter an appearance to defend, and then they take the matter further.
It is common cause, Mr. Dingiswayo, that in October 2017, Judge Makhubele was appointed as the chairperson of the interim board for PRASA. Are you aware of this?
Yes, I am aware.
At the time that Judge Makhubele was appointed as the chairperson for PRASA, or as the chairperson for the interim board of PRASA, was there any pending litigation between CIA and PRASA?
Around September 2017, no, sorry, I'm lying. 2015, 3 summonses landed from the CIA companies claiming various amounts. And in 2016, 2 further summonses landed claiming other amounts. So give or take, in all, you had just over 60 million in those 5 summonses that was being claimed.
Sorry, could you just clear that up for me? You had 5 summonses
Correct, Chair.
from 2015.
So in 2015, 3 landed.
Yes.
I think almost they landed at the same time. I think 2 of them had consecutive case numbers. And in 2016, 2 further summonses landed. And the cumulative claims in all those summonses was just over 60 million.
So all 5 summonses taken together, the claim by CIA against PRASA was over just 50 million.
60.
60.
60.
6. Yes, thank you.
Thank you, Chair. What did you then do with these 5 summons? What happened? What process then followed after the 5 summons?
Chair, these summonses were then allocated to the legal advisors. I must say, Chair, because of my knowledge of the history of CIA, I stayed close to these matters. So they were allocated to a lady called Shumi Mukotedi, and but from time to time we would discuss what happens. So, I mean, in the ordinary course, I would wait for a monthly report or for something to happen. But for these and knowing who the plaintiff is, we agreed that we must keep each other closer to this process to ensure that nothing untoward happens. And that is exactly what happened. So maybe the answer is that Ms. Mukotedi was the contact person, but from time to time, I kept abreast of what's happening.
And what was process instructions in regards to the 5 summonses?
So just a look at the summonses, even before you go to the project manager. In a number of them, Chair, you found discrepancies, glaring discrepancies. For an example, you find that the summons attaches a contract and invoices. Now, when you look at the contract and the invoice that is issued supposedly on the strength of services rendered under the contract, there would be a discrepancy. So I'm just saying, before you go and ask someone whether there's an issue here, as a lawyer who's reading the document, you saw that there were issues. I think 2 of the summonses, one was claiming an oral agreement. PRASA doesn't enter into oral agreements. I think it is unlawful for a public entity to enter into an oral agreement. So that does not happen. And the other one claimed a partly written, partly oral agreement. So there were issues from the word go, but we then took it further and had consultations with the project managers that we believed would know about those projects. And they didn't know about the projects. They didn't know about the invoices. They didn't know about the services that were said to have been rendered. And therefore, that's the basis on which we entered an appearance to defend.
In all 5 matters, as far as you know?
Correct, Chair. I think there was a 6th matter which was paid subsequently.
Now, who was appointed to deal with, who was the lawyer appointed to deal with these matters?
We appointed a gentleman by the name of Madimpe Mukhashwa from a law firm called Diale Mukhashwa Incorporated. And because it was the same plaintiff, we simply asked them to handle all the matters at the same time.
Okay. I'm going to refer you in volume 8 now. I need you to go to volume 8.
I have volume 8, Chair.
Please, can you turn to page 301?
I am at page 301.
On page 301, it indicates the defendant's amended, it's a court document in the High Court of South Africa, Gauteng Division, Pretoria. The case number there is 73933 of 2015, and it's between CIA DP Consulting Engineers and Passenger Rail Agency of South Africa as the defendants. You see that?
Yes.
Okay. Now, if you look in the block, it has a date stamp for the High Court, and it is date stamped the 20th of March 2012. Sorry, 2017.
Yes.
You see that?
Yes.
And it is headed as defendant amended plea.
Correct.
Now, seeing that which headed the defendant's amended plea, were the notice of intentions to defend submitted before that day or filed before that date?
Well, on this date, there would have been the appearance to defend filed as well as a plea. So this document seeks to amend that plea that was filed.
Okay. This is in regards to case number 73933 of 2015. I'm going to refer you now to page 307.
I'm at page 307, Chair.
And the case number there is, it's also a document headed as the defendant's amended plea between the parties CIA Consulting Engineers and PRASA, and the case number there is 73934 of 2015. It's also a defendant's amended plea. Do you see that?
Yes, I see that.
Then I'm going to refer you to page 314. Excuse me. 314, same bundle. The case number there is 47597 of 2016. This one is between CIA Rail Solutions and PRASA, and it's the defendant's plea.
Yes, I see that.
The date stamp on that document is the 22nd of August 2015. Is it 2015? Is it 2015? Yeah, 2015.
Yes, it looks like that. It's a bit faint.
Then I'm going to refer you to page 329.
I'm at page 329.
And the case number there is 2016-47598. And it is between CIDB Consulting, Engineers, and PRASA, and it's the defendant's plea. Do you see that?
Yes.
Okay. Mr. Tingeswai, those documents that I've just referred to, were those as a result of your instructions that were given to Mr. Makhashwa?
Yes, Chairman. If you go through the documents, you will find that there are factual issues that are raised. Those would emanate directly from the internal clients, and then there are legal issues that are raised. And those would be things that we would have discussed with the lawyers and decided to raise in our plea.
Now, in order to assist, on 21 November 2017, Mr. Makhashwa submitted a memorandum in which he dealt with all the matters where defenses had been raised in regards to the CIA matters.
Yes.
I'm going to refer you to that memorandum so that you can assist us. Page 233 of still on volume 8.
I'm on page 233.
Volume 8.
Correct, Chair.
Okay. I'm going to cross-reference you to your affidavit on page 19.
I have both
Okay.
bundles open, Chair.
To assist you, firstly, let me put it this way. Would you be able to remember the claims as per case number as reflected in your affidavit?
No, Chair. I think what could be useful is just to deal with each case. I wouldn't know what is married to what case number.
Okay. This memo of 21 November 2017, it was addressed to yourself and Ms. Shumi Mokotedi.
That is correct, Chair.
Okay. Now, when this memorandum or this correspondence came in, did you go through it and check whether it is in fact what Mr. Makhashwa has written in is in fact the instructions of PRASA?
Yes, that is correct. Although, Chair, this was a letter prepared at the request of the then chairperson of PRASA. We did go through it. We're not just post boxes. We did go through it to make sure that it accords with our instructions.
Well, what was the name of the chairperson of PRASA at the time?
It was, at the time, she was Ms. Makhubele, SC. She was appointed as the judge, and she is now Judge Makhubele.
Let me just get clarity. So before this memorandum, for want of a better name, was prepared, and before you read it, did you say you consulted with Judge Makhubele? Let's just get clarity on this.
Apologies, Chair. In terms of sequence, I was asked by my manager, Ms. Mathangoye, to request this report. I had understood that this was requested by the chairperson, the then chairperson, Judge Makhubele, at a meeting that Judge Makhubele had with Ms. Ngoye.
And when was that meeting?
Chair, I'm not certain. I mean, it would have predated this memo, but it will be around November. Yes. The beginning of November or mid-November. So after the meeting, she came back from that meeting. She said, please request the lawyers to prepare a report on all the matters that they have handled for CIA, outlining what is the claim, what's the defense, and what is the strategy going forward. And this is what was then produced.
Okay. I will not go into that later at this stage. It was just to refer you to that. It contained the instructions that you had given to Mr. Makhashwa. We'll come back to the correspondence just now. Now, you then file your defenses in these matters, and who was representing the CIA companies at this stage?
The CIA companies were represented by Matopo attorneys.
Okay. Was Mr. Makhashwa therefore in contact with Matopo attorneys, Mr. Matopo attorneys?
Yes.
Okay. You file your notices to defend the matters, you file your pleas. What then happens?
No, sorry. After we filed the notice of intention to defend, the plaintiffs in all, I think in most, if not all the matters, applied for summary judgment. We opposed the summary judgment application successfully, and were granted leave to defend. We then raised an exception because, as I said, just on the face of these documents, there were just discrepancies. That exception was not, those exceptions were not successful. And then we filed pleas after that.
What then happened?
I think there was some discovery. I think there were discovery affidavits that were exchanged, Chair. I may be incorrect here, but I think there was discovery, and I think there was a set down of the trials for hearing. And at that time, when we were attending to the pre-trial processes, the issue of, because some of the contracts, where there were contracts, written contracts, there were arbitration clauses. So the issue of the arbitration clauses arose, and we wanted to know how we're going to deal with it. I'm not certain who did the approach, either the plaintiffs or us. We decided, why don't we consolidate all these matters and then take them for arbitration? So I'm not certain where that request came from, because the request would have come to me from Ms. Mukotedi so that I can authorize that, which I did gladly, because we were very confident in our merits. And we're looking forward to removing these claims from our contingent liability list. So then the matters were referred to arbitration. Retired Judge Brand was appointed to be the arbitrator. And I think a pre-arbitration meeting was arranged.
Sorry, are you saying you were confident in all the matters or a matter?
In all of them.
In all of them, you were confident that you're having a defense?
Yes.
Okay, thank you.
Chair, we were confident that the claim, because I mean, we are now at pre-trial. They have not corrected the glaring discrepancies in their papers, which affect their claims. So we thought maybe when this thing is raised, then maybe they'll amend their particulars. They didn't. They stuck to their particulars. And so on those papers, we were very confident.
And that would include matters in which reliance was placed on oral contracts as well?
Well, Chair,
where you felt confident?
the ones based on oral contracts were the easiest to deal with. Because a public entity cannot enter into an oral contract. Section 217 is very clear. If you enter into an oral contract, you cannot test it against 217 of the Constitution. So on the oral one, the partly oral, partly written, we're most confident. But the interesting thing is that where they had the actual contracts, you look at the contract and the services that are stated in the contract. You look at the invoice that is supposed to be issued on the strength of this contract. They are not talking to each other. And up to the pre-trial stage, this is not corrected by the plaintiffs.
In any event, we know that all the matters went to arbitration.
Correct.
And arbitration awards were made in order of court.
Yes, there was a settlement. They were settled without our knowledge. They were settled without the knowledge of our internal clients, the executives, who were in charge of the matters. They were settled without the knowledge of the project managers. So the people that we had understood were project managers, Mr. Kobue and Mr. Vermeulen. They didn't know about the settlement. I have no idea who was consulted to decide.
But who settled on behalf of PRASA?
Chair, as they say, Commissioner, hindsight is 20/20 vision. We established that the chairperson of the board, Ms. Makhubele, settled Judge Makhubele, settled the matters. She was assisted by Mr. Lindikaya Zide and Mr. Kromet Molepo. But those two people, Mr. Lindikaya Zide and Mr. Kromet Molepo, are just like me. Mr. Zide is a lawyer. I think, I don't know what Mr. Kromet Molepo is, but he's not an engineer. All these things dealt with engineering services. So the people whose fingerprints you see when you look at the documents that related to the settlement would not have known anything about it, would not have known anything about the projects, would not have known whether those services were rendered or not, would not be able to say if those services were rendered, whether they were adequate. And I'm not saying that to disrespect them, Commissioner. That's why I said like me. I mean, it's like me walking into a technical environment. I wouldn't know my right from my left. Those are the kind of people whose fingerprints you find in the settlement, in the documents that show the settlement.
Mr. Tingiswayo, sorry, Chair, I don't know if judgment, I was going to lead, we were still coming to that, we're just leading it in a
Okay, I'll come
chronological
back
order.
later. You proceed.
Yes, thank you, Judge. Can I take you back to your evidence which you gave with regards that there was a pre-trial and documents had not been corrected? I'd like to go back to that issue. After that pre-trial was conducted, what then happened? Do you remember the dates when the matter was set for the arbitration?
I think the dates are here, Chair. There was a September date.
Can I refer you to your volume 20, page 20, in paragraph 32?
Oh, yes. Yeah, sorry. Yeah, there was 11 to 22 September. That was supposed to be the date of the hearing, of the arbitration.
Okay. Did prior to that date taking, or prior to those dates of 11 to 22 September 2017, what happened prior to that?
Chair, as I testified, you hold a pre-arbitration meeting was held. A timetable was agreed between the parties. There was a request for further and better discovery.
From whom?
From us, from PRASA. And there was a request for further particulars from PRASA. So I think at the time of the pre-arbitration meeting, these documents have been served on the plaintiffs. So one of the dates that are agreed at the pre-arbitration meeting is the date for the filing of the further and better discovery by the CIA companies and the dates for filing of the further particulars.
As far as you know, were those documents ever filed?
Never filed. So the reason that the matter didn't sit as it was supposed to on the 11th to the 22nd was because those documents were never filed. I know that there was, a follow-up from our lawyers that when are we getting these? An undertaking was made, it was never met. So by the time the 11th came, documents are not filed, matter cannot proceed, it was postponed.
Okay. I want to refer you to paragraph 33 of your affidavit.
33.
Yes. Still on page 20.
Yes.
It is indicated that in the meantime, the liquidators decided to institute an inquiry in terms of section 417 and 418 of the Companies Act. You see
Yes.
that?
Yes.
Can you please tell us about that process and what did it take place?
Chairperson, I think beginning of 2017, the directors or the director, I'm not certain whether Mr. Mabunda was the only director, but they voluntarily placed CIA, the CIA consulting engineers. They placed that in liquidation, voluntary liquidation. So they took a resolution and they placed CIA in voluntary liquidation. So the inquiry, I don't even know if it's correct to call it an inquiry. it has too many characteristics of a sham to be called an inquiry.
When you say it was a sham, I think that's the word you use, you shake your head.
I'm nodding, Chair.
Yes, yeah.
Yes,
That was the 417, isn't it?
that is correct, Chair.
Had it been set down, and do you know the date it was set down?
How we learned of it, Chair, was when Mr. Vincent Kobue and Mr. Tony Vermeulen came to the legal department with subpoenas. They had been subpoenaed to come and appear at the inquiry. So they asked for assistance. So they asked, what are we supposed to do? Because, it's not a subpoena about your child maintenance. It's a subpoena about PRASA issues. So they come to the PRASA legal department to say, what do I do with this document? And what documents do these people want from me? Because the subpoena is requesting that you must bring documents, and there was no clarity on what exactly should be brought. So we then said, okay, because Diale Mokhashwa is on brief, we directed them to Diale Mokhashwa to say, can you assist these colleagues with this? And they assisted them. What I understand happened is that Diale Mokhashwa attended the hearing, and they didn't participate much at the hearing. And I mean, the other things that I learned from the hearing are the reports that were requested by the chairperson from the PRASA employees who were subpoenaed to the inquiry. And I'm not sure, maybe we will be getting there.
We will get there, Mr. Tingiswayo. Can you just take it one step at a time?
I apologize.
Thank you. The inquiry you talk about, is that the inquiry that happened between the 28th and the 31st of August 2017?
Chair, I'm not certain about the dates, but that sounds about right.
Your department, legal department, instructed Mr. Mokhashwa to go, and you say that who attended but did not participate. What exactly was the role of Mr. Mokhashwa at the inquiry?
Well, Chair, you had two managers who were having this subpoena. They didn't know what to do with it, so they just needed support. And we said they would feel better at the inquiry if they know that there's a lawyer there who's representing PRASA and who's representing them, who's there to assist them. So that was the role that we asked them to play.
These the documents that came, the inquiry proceedings, the actual inquiry proceedings, and the findings of the commissioner from the inquiry, did you ever get hold of those documents? Were they ever submitted to yourself?
Yes, I don't remember how we found them, but we only got the transcript of the inquiry around probably March or April 2018.
Okay. What happens after the inquiry, the arbitration, the 417 inquiry, what then happens? Because it happened, that inquiry, as I've indicated, was on the 31st of August 2017. What then happens?
So the next time I hear of the inquiry is after the meeting that was attended by Ms. Ngoye with Judge Makhubele. Because from my understanding of that meeting is that the judge was interested in these matters because of a report that had been shared with her that comes from the inquiry. So that's the next time I heard about this inquiry.
The question was when?
That is in November, Chair, just before the report that is in 233 of volume 8 was penned.
Did you discuss the meeting that Ms. Ngoye had? Did you discuss it with Ms. Ngoye, the meeting between herself and Judge Makhubele?
Yes, we discussed. I mean, she had instructions for me from the meeting. So
And what were those instructions?
that we should request Diale Mokhashwa to produce this report that is on page 233. And then after that, I called them to make the report available.
So when you say that report, did you then receive this report that you've referred to? And as you've said in your evidence previously, you then went through this report. Who did you send this report to?
I don't remember. I suspect I would have sent it to Ms. Ngoye, who would have then sent it to either the company secretary or to Judge Makhubele herself. I'm not certain how the communication lines flowed. And Chair, I must say, a request like that from a chairperson of the board to say, can you tell me more about these matters, is a normal request. So from the meeting that Ms. Ngoye had with Judge Makhubele and the request that flowed from there was nothing unusual. But the things became very unusual soon after that.
Okay. After this report of 21 November 2017 was submitted, what then happened?
Then we received a response from Judge Makhubele through Mr. Zide. So she wrote a memo.
I want to refer you to page 248 of your volume 20. Do you recognize that document?
Yes, this is the memo that was received from Judge Makhubele.
Page 248 of volume 8. In that memorandum, I'm going to refer you to paragraph 4.
Yes.
This is the, as we said, memorandum from Judge Makhubele, but it's written from Chairperson Interim Board Advocate T.A.N. Makhubele SC, dated 28 November 2017, heading is CIA Consulting Engineers, Pty Ltd, in liquidation, inquiry in terms of section 4171 and 4182 of the Companies Act, 61 of 1973. It is addressed to Mr. Zide. In paragraph 4, it says, it also appears from the report that at some point the matters were referred to arbitration, but what is not clear is whether this happened before CIA Consulting Engineers went into liquidation or not. were you able to indicate whether or not, were you able to respond to that paragraph 4?
No, I didn't think there was a response necessary to this. There were other things in this memo that required were specifically addressed to us and other people and required a response.
Okay. If you go on to paragraph 8, paragraph 9 on page 251.
Yes.
It says, kindly request the officials indicated hereunder who's testified at the liquidation inquiry to submit written reports and confirm their testimony. 1, or A, it's Mr. A.M. Vermeulen, the infrastructure operations at Prasa Rail. B, Mr. Vikobue, executive manager for infrastructure. And C, Mr. S. Baltic. Were those reports obtained?
We obtained reports from Mr. Kobue and Mr. Baltak. I think his surname is TAC, if I'm not mistaken. At the time when we were requested to get information from Mr. Vermeulen, he had already retired. So we simply informed Mr. Zide that Mr. Vermeulen has retired, so we can't get anything from him. I think we're given about 24 hours notice for all these things to be done, because I think the chairperson was saying that she wanted these reports so that she can report the matters to the board board meeting that was going to be held on the 1st of December.
In paragraph 11 of that same minutes, which is on page 251, the memo, the memo also indicates that, and paragraph 11 is carried on onto the following page. She then also wanted a report from Ms. Ngoye about the involvement of her unit, in particular with regards to provisions of instructions to Mahashwa Diale attorneys on the issues that I have raised. You see that?
Yes, I see that.
Okay. Now, on page 253.
Chair, maybe before we move away from this, this is unusual. This is where the strangeness that's coming in when there is this type of interrogation of which goes to almost being operational by the chairperson of the board, but that has to be placed in context. The chairperson is a month at this point in the board of PRASA. The board is coming into an organization that at October 2017, it has not submitted the financial statements for the previous year. So financial statements are late. So PRASA has not accounted for how it has spent circa 26 billion that was given to it by the fiscus. We have very important litigation ongoing. We're busy preparing the Siangena application to review and set aside a 4 billion contract. PRASA has spent over 100 million doing forensic investigations to assist the Hawks, the Directorate for Priority Crime and Investigation, in finding people who are responsible for fraud, corruption, and all manner of things. So there are a lot of important things that are happening at the time that this board comes to PRASA. So I'm saying that context is important to then say, why is the chairperson so concerned and spending time on this matter that relates to this one company, which I think at that time is known to not be very honest, and there's a lot of allegations about it and its relationship with PRASA. So you have a board that has a mammoth task, and the leader of the board is focusing on this very small matter. And having read the report from Mukhashwa, because once you go through the report from Mukhashwa, you realize that there are problems here. And probably if there was interest in the matter, then you say, let me not waste time with this. Let me deal with the other more pressing issues that PRASA is bedeviled with.
Sorry, you must explain to me now. Why do you say it was strange for the chairperson of the board to be concerned with issues like that? I think in your previous evidence this morning you said where she intervened it was expected of her to do so. Now you say it was strange. Could you expand then?
I'm happy to, Commissioner.
Yes, please, we want to hear that.
I am saying that we have had instances where a supplier of PRASA goes to a board member and says, your people there are giving me runarounds. Can you find out what's happening with my matter? And the board member comes to the people involved and says, supplier X is saying you are giving him runarounds. What is happening with that? So I'm saying that part is normal. And then you then give an explanation. So I'm saying what becomes abnormal here, with this memo particularly, is that you've made the inquiry, you have been given what is a very clear and detailed explanation of the fact that this supplier that that has approached you is a supplier that has initiated litigation and is unable to prosecute it to its logical conclusion. So you have a plaintiff who is dominus litis, because this is what this report is saying. Saying you've got a plaintiff whose papers are a mess, who is not prosecuting this litigation. We have ensured that we don't delay on our side. The matters are consolidated. They are referred to arbitration. Everything is being expedited. But this plaintiff is stuck. This person that is asking you to help them is stuck in the mud of their own creation. So this is what this report is saying. Now, to come after that report and write a memo like this, so take that as one set of circumstances. The other set of circumstances is, what are the issues that are most pressing to this organization? You are not a legal advisor of this organization. You are not Shumi Mukotedi. See, Shumi Mukotedi sleeps day and night these matters. You are the chairperson of a board of an entity that has not told the public what has happened to 26 billion that the government gave to. There's a lot of money that is spent in investigations. The investigations are stuck at the hawks. Nothing is happening. Your predecessors took the unprecedented step of suing the hawks and the NPA so that the money that you spent in investigation, we can see people in orange overalls. So that is important. There's litigation of a 4 billion contract that we're trying to get set aside. That is important. So if the chairperson of the board is worried about those things and spending time in those things, that is normal. But where the chairperson of the board is spending time on a 60 million claim, whose claimant is unable. This report said these people are asking you to rescue them from the mud that they created for themselves. This is the point where you say, I'm walking away, I can't help you, I tried. But so that for me, Commissioner, with respect, is very, very strange.
Well, the fact that there was generally known and publicized corruption at PRASA at that time, starting from before, 2012, like Mr. Molaki Montana and the other people, could that not have been a valid reason for the chairperson to do what she did, to find out what's happening?
Chair, if the chairperson has that in mind, then the chairperson would know that this supplier in particular is one of the suppliers that have most of those kind of allegations against it. So the relationship between it and PRASA is alleged to be corrupt, that one. So if the concern is there's a lot of corruption, if you know anything about the corruption of PRASA, there are certain names that will just come up. And Siaya Makensa Mabunda is one of those names.
Was Judge Makhubele the first chairperson of the board, interim, that paid so much attention to what you call operational things? Or did previous board chairpersons also do that?
Chair, what I said before is that the request, so it was normal for a board member to say, so-and-so is saying you're giving them a runaround, you tell them the facts, they go away. So that is a norm. And maybe to answer directly your question, Judge Makhubele was not the first to be operational, but whenever there is such a thing, there is some suspicion. I'll give you an example. We had a matter that appeared to trouble a board member after the board of Judge Makhubele. It was a claim for about 35 million.
When was it?
This would be around 2018, 2019.
But she was not there anymore?
Yes, I'm answering your question, Chair, to Commissioner, to say, was she the first? I'm saying she was not the first. So we have had that, that instance where but there's always something wrong with that. Because, you know, in the ordinary course, if you're operating at that strategic level and you get such an inquiry, it's a nag, simply because there's many things that are happening, many moving parts, important matters. And when the nag comes, maybe you owe someone a favor or you feel that you have to make the inquiry, make the inquiry. And when a cogent explanation is given, normally the board member goes away. But where there's something wrong, the board member does not go away. They keep coming. They keep asking for reports. They keep asking for memos. There's something wrong there.
Advocate Zungu, I'm just finishing one question, sorry. Now here you are, you have established that Judge Makhubele has arrived at the board in October 2017. She is interfering in issues that she should not do so. What did you do about the situation?
I'm
talking about you personally.
Yes.
Yeah.
Yes, I mean, we watched it. Remember, these people are looking for payment out of PRASA. So we're watching this thing to see what is going to happen here.
People looking for payment, the service providers.
Yes, CIA was claiming that they are owed the circa 60 million.
Yeah.
So we watched it. And where we could, we blocked it. Because we're not running PRASA. We are legal advisors. Unfortunately for CIA and those who were pushing for this payment, whenever, after the settlement, whenever payment was supposed to be done, people came to us to ask us, because you had lawyers writing to the CFO, for an example, demanding payment. And the CFO is sitting in her office, is seeing a letter from lawyers. There's a legal department in this place. The first place where she goes to is the legal department. So we get there. When she comes, we say, don't pay. Someone at PRASA Tech comes to me. The CFO went to Ms. Ngoye. Someone at PRASA Tech comes to me. We say, don't pay.
Maybe I should remind you that they ask you what did you do personally.
I told them not to pay.
Thank you. Yeah.
Well, it's gone 11:15. Would this be a convenient stage, unless you want to carry on?
Chairperson, I can continue. Maybe can you start at 10:30?
Yeah,
11:30.
We can, yes.
Is it fine, Council? Okay. Let's proceed. We received this memo. I want to refer you to page 254, still on volume 8. 254.
I'm at 254?
At the bottom, there's this is emails.
Yes.
We note that it states from Fanny Dingiswayo, sent Wednesday, November 29, 2017, 4:23 p.m. It is to Vincent Kobue and Soren Baltic. Subject matter amended memo to Mr. Zidem. Please have regard to paragraph 3, please have regard to paragraph 9 of the memo from the chairperson of the board and provide the information that she requires. Please note that this information is required by noon tomorrow.
Yes, this is the email that I sent. Like I said, we were given very short deadline to submit the information that the chairperson required.
Okay. On top of that one, it's on same date, 30th of November 2017. It's from Vincent Kobuwe, and it's at 8:15. That is the next day. Now on the 30th, it's addressed to yourself. Same subject heading, and it says, "Good day, Fanny. This serves to confirm that I'm working on a response as requested. Please provide me with the following referred to in the memo from the board. 1, the interim report that was prepared by the commissioner as referred to in item 5, and 2, Mahasha Diale attorney's report as referred to in item 5. Were these reports handed over to Mr. Kobuwe?
No, so the first one was not. We didn't have the first one. I mean, this was maybe, I could call it the unfairness of the request to these employees, which Mr. Kobuwe, noted correctly, that the memo says you have made certain concessions. There's a report, an interim report from the commissioner. The interim report says you have made major concessions at the hearing. Tell me what happened at the hearing.
Did Mr. Kobuwe submit a report, and did Mr. Baltic submit a report?
Correct. Mr. Kobuwe submitted they both submitted reports, yes.
And in preparation of the reports, were they ever handed over with the commissioner's interim report?
No. So the three of us submitted reports.
Okay.
I submitted a report, Mr. Kobuwe submitted a report, and Mr. Baltak submitted a report.
Okay. I want to refer you to the report of Mr. Baltic.
Yes.
This report is found on page 257, but I want to go on to page 258.
I'm at 258.
The last sentence before his name, Baltic. He says, after the testimony, PRASA Legal Department has instructed me not to enter in any discussion with Mackenzie Mabunda or with the commissioner. My involvement by now in this process was finished with this instruction. Do you see that?
Yes.
What
yes,
is your comment about that?
This is not true. There's no one in the legal department who had the right to instruct Mr. Baltak. Nobody.
Who was his supervisor?
It was Mr. Pete Sibula.
Okay. I'm going to refer you to...
Move on. That last sentence that was read to you.
Yes.
After the testimony, PRASA Legal Department has instructed me not to enter into any discussion with Mackenzie Mabunda or with the commissioner. See, that never happened. By that I mean nobody from the legal department, which was your department,
Correct.
had spoken to Mr. Baltic, as far as you know.
No, Chair. He is saying he was instructed. I'm saying that there's no one in the legal department who could instruct Mr. Baltak, who had the authority to instruct Mr. Baltak.
Yes.
Mr. Baltak was in trouble here. He had concluded a contract with CIA when he did not have the authority to do so. On his version, CIA performed in terms of whatever contract. Now, this is his problem. How do I get those services paid for? Because now this service provider comes to him with an invoice, and then he has to process it. He can't pay it from his back pocket. It has to go through the normal payment process. The payment process says, where is the contract? By my reading of this, it seems as if the essential terms of that contract, whatever contract, were not there. Because in an engineering contract, it's very defined. Say, this is what I'm going to do, this is how much it will cost you. There's no need after the fact to now start talking about how much is the cost. No, because if I've delivered this, the contract says it's R4, pay me R4.
No, I understand that. But as a fact, did Mr. Balte give evidence at the liquidation inquiry?
Yes, he did.
And as a fact, after he had given that information, did the legal department just speak to him?
No, Chair.
That's all I wanted to know.
We didn't speak to any of the colleagues. It's a subpoena. It seeks their appearance personally, and they must bring documents. We assist them with lawyers. I only learned about what happened at the hearing when I read the transcript in 2018.
No, that's where I was going. So you, would say that as far as you are aware, nobody at the legal department had instructed Mr. Soren Boltek.
Chair, I'm saying two things.
Yeah.
I'm saying that, and I'm saying nobody could.
Yes, no, I understand.
Yes.
Yes, thank you.
Thank you, Chair. Chair, can take the tea break at this stage, because I'd like to go into page 259 of the memo from Mr. Tingiswayo addressed to Mr. Lide Kayaside.
Yes, we'll take the tea adjournment now. Thank you.
Thank you.
Yes, thank you. May we continue? And to remind the witness, sir, you still under oath?
Yes, Chair.
Thank
Thanks.
you. Mzungu?
Thank you, Chair. Mr. Tingiswayo, I'm going to refer you to, still on volume 8, page 259. That's a memorandum to the acting group chief executive officer, Mr. Lindy Kaya Zide. It's from the group legal services, Mr. Fani Tingiswayo. It's dated the 30th of November 2017, litigation against CIA Consulting Engineers in liquidation. You see that?
Yes, I see that.
259, page 259 in volume 8. Okay. I'm not going to go through the whole correspondence. I'm sure you have had sight of it. There are just certain aspects of that correspondence I'd like to refer to. On page 259 at the bottom, it is indicated DM was therefore not instructed to deal with the liquidation. Who is DM?
So if you go to paragraph 1, the second line.
Right. Now, when you say DM was therefore not instructed to deal with the liquidation, what did you mean?
There was an issue raised in the memo from Judge Makhubele around whether the CEO had instructed Diale Mokhashwa in relation to the liquidation. And that was to respond to that. Because I think in terms of the delegation of authority framework, the CEO has the delegated authority to deal with liquidation. So if PRASA were to apply for someone's liquidation, as I understand it, the CEO would be the one that would have to deal with that matter.
If you read 2.1, if you read paragraph 2.1 there on top, it's referring to it's referring to the liquidation inquiry where Kobue and Vermeulen and other PRASA employees went to testify. Now, when you say DM was therefore not instructed to deal with the liquidation,
Yes.
taking into consideration that DM or Diale Mokhashwa was at the inquiry, what did you mean when you put this there? Diale Mokhashwa was therefore not instructed to deal with the liquidation. What did you mean?
So what I meant, Chair, is that PRASA did not apply for the liquidation of CIA. Because if PRASA was applying for the liquidation of CIA, my understanding of the delegation of authority framework is that then the CEO would be the one that gives instructions. So I think Judge Makhubele understood the delegation of authority to mean that if there's any liquidation issue and anyone of PRASA gets involved in it, then the CEO must give instructions. I understood it differently, and that's why I said that to try and separate the two.
Okay, if you go to page 264, it's still on the same memo.
Yes, I'm at
The
264.
last sentence, it says, "We will be available on Friday in case the board would like to ask any questions on this matter."
Yes, Chair.
Were you ever invited to the board to probably provide insight or respond to any further issues with regards to the issues that had been raised in the memorandum from Judge Makhubele to Mr. Zide?
No, Chair. Remember the tight deadline that was provided was, the justification for it was that there's a board meeting on the 1st. And this matter would be tabled there. So this line is included to say, if the matter is going to be discussed by the board, and the board would like to discuss it with us, we are happy to make ourselves available.
On page 266 is a correspondence from Diale Makhashwa. It's addressed to Ms. Martha Ngoye, Mr. Fani Dingiswayo, and Ms. Shumi Mokotedi. It is dated the 30th of November 2017.
Yes, I see that.
Did you receive this correspondence?
Yes, we did receive it.
Now, the correspondence of the chairperson or the internal memo of the chairperson, which appears on page 248,
Yes.
was that forwarded to Mr. Diale Makhashwa?
Yes, it was.
Okay. And do you remember who forwarded that that internal memo of the from Judge Makhubele?
It would be me, if I remember well. I'm not certain, but I mean, I was the one doing the correspondence between Diale Makhashwa and on this at this stage of this matter.
I'm asking this question because I've gone through this memorandum of 28 November 2017
Yes.
by Judge Makhubele, and I do not see anywhere in that correspondence where it is indicated that there was anything further that was required from Diale Makhashwa.
Oh, so what the chairperson had said about Diale Makhashwa, which we thought needed a response. If I can just be afforded a moment, Chair. So there's a number of things that are said about Diale Makhashwa in the report. I mean, if you can look, in the memo from the chair, which starts at 248. There is mention of them on paragraph 2 at 248, paragraph 3, paragraph 5, paragraph 6, on 2549, sorry. So there's a lot that has been said about them, which we felt is necessary for them to weigh in on those things, because it's things that we didn't know about. You know, it's emails that were exchanged between them and Advocate Bottas. I mean, they would be best placed to respond to those things.
Okay. You indicated that there was a tight timeline with regards to submission of these reports as a result of the meeting that was going to be held on the 1st of December, board meeting.
Yeah, well, this is what was said by the chair on page 252, paragraph 12. She says the reports from you, Ms. Ngoye, and officials indicated in paragraph 9 must reach me on or before 12 on Friday, 30 November, to enable me to report to the Board of Control on 1 December 2017.
Okay. I want to, sorry, Chairperson, I didn't I don't remember if I referred to volume 6, but I'd like to go to volume 6. Volume 6, page 799, it's written at the bottom. Have you,
Sorry, Chair, whilst she's looking for volume 6, I knew that there was something that I was missing. So, what's going on here? Oh, sorry. On page 250 of this volume, volume 8,
8?
at the top, the chair says, you have noted from the bundle of documents from CIA's attorneys that these assertions may not be entirely correct. She's referring to the fact that Diale Mukhashwa said that they do not have a copy of the interim report. So this was a big concern for us. We cannot have our lawyers lying to us about matters that they're handling. And this is one of the main reasons that I said, please tell me what's going on here.
I've written on my one. Sorry, my one is scribbled.
You've got it there. You've got it. You found it. Okay.
Please. The legal panel is suspended with immediate effect. You see that?
Yes.
And the next one, which needs to be read in conjunction with bulletin number 2, which is bulletin number 3, is any legal services sought must be procured through SCM processes and in consultation with the chairperson of the Board of Control on all matters relating to the investigations only. You see that?
Yes.
Now, I want to ask this. Did you indicated to us at the beginning that summons would be brought and that you would peruse the summons, consult with the business unit, and determine whether or not you defend the matter? You remember that?
Yes, I remember.
Did you apply or did you implement this resolution 2 and 3?
2 and 3.
Yes.
Well, the bullet point 2 is just a very strange thing that says the panel is suspended with immediate effect. So that there was just sort of a direction. So 3, Chair, PRASA has a number of personal injury claims because we ferry people. So I think the one time about 3 or 4 summonses arrived that related to people making claims for personal injury who got injured on the network. I took those summonses to Mr. Peter Malele, who was at the time the acting chief procurement officer, and I asked him to please procure legal services for us to deal with those summonses. Nothing happened. Initially, he didn't even want to receive the summonses. So because he didn't want to receive them, I scanned them and I emailed them to him, and I said, in line with the board resolution, please help us get legal services. Nothing happened. Fortunately, it was around December, so we were saved by Diaz Non, so I had a little bit more time. But during that time, there was litigation in Cape Town that was instituted by Unite Behind, challenging this resolution. Mr. Lindikaya Zide deposed to an affidavit in the context of that litigation. And one of the things that he said in that affidavit is that this resolution is not the resolution of the board. This document here is not a resolution that was taken by the board. So after that, we reverted to the normal way of instructing attorneys. Because I mean, what that meant is that the panel is not suspended. We don't have to follow this. I'm not sure how you follow this three. I mean, that's one of the things that we're asking from the board around the practicalities of this.
Okay. Now, thank you on that, Mr. Tingiswayo. I want to take you now to the events that followed the 1st of December. After the 1st of December, after 1 December 2017, did you have any further dealings with the CIA matter? Or let's say, was there any further dealings that you had with the CIA matter during December 2017?
No, Chair. Around December, early December, Mr. Mukhashwa came to my office. He greeted me, we had small talk, and then he kept looking at his watch. And then at some point, he asked me, are we not going to the meeting with the chairperson? So I was like, what meeting? He says, no, I'm here for a meeting with the chairperson. Like, no, I'm not invited, so please let me not delay you. Go ahead to have your meeting with the chairperson. He went and had the meeting with the chairperson. And I said to him, you know, I don't want to put you in a difficult position. The less I know about that meeting, the better. Because there should be a reason why the chairperson wanted to meet with him alone. Then around the 15th of December, I think on the 15th, because I was a little bit, you know, this thing is nagging in my head that I wonder what's going on to those matters. I called Mr. Diale, and sorry, I'm making the same mistakes that were made by my boss. I called Mr. Mukhashwa. Mr. Mukhashwa, I don't know what's going on with the CIA matters. Where are we with them? And he said to me, Ish, I've been barred from talking to you about these matters. So I was like, oh, okay, sorry. Let's not take the matter any further. And I ended the call. So those were my, call it interactions with the CIA matters in December.
Tell me, and did he indicate who barred him?
Yes,
From-
he said he was barred by the chairperson.
Okay. Thereafter, did you have in January 20, now we're in January 2018, did you
Yes.
deal with the CIA matter?
I may not be sure about the dates, Chair, but early in 2018, this is when there was push for payment. So I think the first attempt was on something sent to the CFO, and then the second was an inquiry from someone who works at Prasatech, who was asking me for invoices. So I'm not sure about the dates, but I know that it was early in 2018.
I want to refer you to page 292 of volume 8,
Volume 8.
page 292. Do you see that?
Yes, yes.
It's
yes.
an email from Rose Manyosa.
Yes.
So that we can contextualize those emails. They actually begin on page, no, that's right. They begin there on, at the top on page 292, you see that?
29?
292 at the top.
Yes.
No, they actually begin at the bottom and it goes upwards, sorry. It begins at the bottom and goes upwards. You received an email from Miss Rose Manyose, and it was CC to Miss Mamsi. What was this email about?
So I think the yes. So on 293, Chair. Sorry to move away from where I was directed. Almost at the top, there's an email from Yvonne Page to Mamsi, which is dated 10 January 2018, 1:51 p.m. So remember I said Yvonne got the inquiries first, and then after she received the inquiries, then the next inquiry came from technical. So from this exchange, it looks like Yvonne then went to Prasa Technical, to Mamsi, sorry, I think who was the CFO at the division, and asked her about these things. Now, I think on the instructions of Mamsi and seeing lawyers' letters, they are then sent to me by Rose to say, to ask for the invoices. And then I respond. And I think this is what Commissioner Mushidi raised earlier about what I did. So this is one of the things that we did after to stop the payments. You know, to warn people that if you pay this, you are paying an irregularity, you are paying something that says Prasad does not acknowledge liability, and it's a settlement that was reached at best under very dubious circumstances.
When is your next encounter in regards to these matters? With regards to the CIA matters?
I think, Chair, around the 5th of March, 2018, I received a call from a lawyer that I worked with before joining PRASA. And after pleasantries and everything, he says to me, I need some information. A client of mine has done some construction work for Mr. Mabunda. And this client of mine tells me that Mr. Mabunda has promised that he will pay that client from monies that he expects from PRASA. So he wanted to know whether I know about this, because I think his client wanted to know whether to put pressure on Mr. Mabunda or to think that this is a legitimate promise. So I said to him, no, I don't know about that. And then, because I mean, you know, from time to time you think about these CIA matters that I wonder what's going on now. My first port of call was to call Mr. Mokhashwa and ask him, where are we with these matters? Mr. Mokhashwa was very relieved. He says to me, we've been writing to Mr. Zide asking for instructions, and there's been radio silence on the other side. So I'm happy that someone from PRASA has called me about this. I'm like, so what's happening? He says, no, there's an application set down for the 9th of March, 2018, to make the awards orders of court. I said, can you please share that application with me? Then he sent it to me. And when I looked at the documents that he sent to me, I was shocked. I was shocked that at the terms of the settlement. I was shocked that these matters have been settled. And I think on the same day, if I'm not mistaken, there was an EXCO meeting. And I told Ms. Ngoye that the matters have been settled and this is what is happening. So I'm going through all these documents and seeing very strange things in these documents. And she's at EXCO, and at some point she tells me she asked the 2 executives who would be involved in these matters, that is Mr. Pete Sibula and Mr. Kevin Munsami. Kevin Munsami was the CEO of PRASA Tech. Pete Sibula was a group executive of a department called Strategic Asset Development. And they didn't know anything about the settlement. So Ms. Ngoye was on her way home, so she comes to my office, she tells me this. And one of the things that, so I say to her, no, I think I'm ahead, Chair. I think that what I'm talking about may have happened on the 6th or the 7th. But, yes, but what we decided to do was to instruct other lawyers, because the idea was to challenge the settlement. So because the exco happens on the day after we've put a notice of intention to oppose. Our then lawyers, Bowmans, they receive a letter from Matopo attorneys, which has transcribed what in the letter is referred to as a text message that was sent by Judge Makhubele to these lawyers. And that text message says Bowmans is not authorized to do what they are doing and other things.
But just on that score, I want to refer you why we did.
Yes.
Refer to page 298.
Thank you. Yes, that's why I did remember that I'm wrong, because we received the documents around the 6th, and this is around the 8th. And this is the letter that I'm talking about, Chair. Thank you, Ms. Zungu. And the text is on 299, the transcribed texts, that's 2 of them. It's on 299. So that the one that is between the numbered paragraph 2 and numbered paragraph 3 and in italics, that is the message that was said to be received from the chairperson. Now, chairperson, sorry, I have to get this thing right. This was a message received from Judge Makhubele. This probably in response to something that was sent to her about Bowmans acting for PRASA in the matter. Now, a stranger one is the one at the bottom. So the lawyers of CIA were, according to this letter, given communication between the chairperson, Judge Makhubele, and the then acting group CEO. I mean, this is what I was referring to earlier, Chair, when I said what was coming out was shocking. I could not believe that a text message like this, the one on top, was sent by a chairperson of the board to attorneys acting for CIA, or somebody who has access to them. And that whoever that person is also got this communication between the chairperson, Judge Makhubele, and the CEO.
And who was the CEO at the time?
It was Mr. Kromet Mulepo.
This correspondence is dated 8 March 2018 and it's addressed to Bowmans. And this correspondence is brought to your attention at PRASA.
Yes.
Sorry, Chairperson. This correspondence is brought to the attention of PRASA because you've now appointed Bowman Gilfillans. At this stage, 8 March 2018, you've testified that the matter is in court on the 9th of March 2018. Am I correct?
Yes,
Where
the
now
matter was in court on the 9th. It was set
Okay.
down for the 9th of March. So Bowmans would have submitted a notice to oppose maybe around a day before this, and then this is the letter that they received.
Did you ever request Bowman to maybe inquire from Mr. Matopo where they had received that, those messages from?
No, I think the letter is clear. On page 299, the source of the message is Judge Makhubele. So there was no need to make that inquiry.
The message on page 3.
Page?
Sorry, the message on paragraph 3.
Yes.
I want to take you to where it starts with the matter. Can you pour me some water? The matter involves me directly, and I would have expected a courtesy briefing before decisions were taken. Did you discuss the issue of instructing Bowmans with Mr. Molepe?
Yes, we discussed it with, in a meeting with Mr. Molepo, Mr. Zide, Mr. Mukhashwa was in that meeting.
Okay.
And Ms. Ngoye attended, and I also attended. So we told them that we are going to challenge the settlements. Now, Mukhashwa couldn't be party to the settlement and then challenge them. So it was a simple matter like that. So he needed to get other people to assist. And he understood, everyone in the room understood, and were given a go-ahead to proceed in that manner.
What takes place on the 9th of March 2018? What takes place on the 9th of March 2018?
A movie, Chair. There's 4 applications. So they were in different courts. So the first thing we talk about with the lawyers of CIA is that, no, can we just get these applications moved into one court so that we don't have to be running around?
Sorry, just before you continue, did
Yes.
you go to court on the 9th of March 2018?
Yes, it's one of the very rare moments that I went to court when there's a matter for PRASA because of all the drama around it. So we said, yes, let's do that. Let's get them in one court. Advocate Botes is running around, gets the files, talks to the clerks and everything. The matters are before Judge Holland matter. The matters get called. No, sorry. So after the matters are moved, we now know where we are on the roll. So there's no need to be in court. So now we are talking about the matters. It's myself, it's our counsel, and our attorneys. And we having a chat with Advocate Botes. Advocate Botes is like, what is this about? Because these matters are settled. I don't understand what's going on here. Then you're like, no, there's no board resolution. He says, no, there is a board resolution authorizing the settlement of these matters. And he says, I have it in my chamber. So for one moment, I thought maybe this was, this man is joking maybe. Then we say, please get it for us. Disappears, comes back. He's got a letter in his hand. I really want to see this letter. And he keeps talking, and he's folded it in half. I'm trying to peep to see what is exactly in this letter. And then eventually he gives it to us. Okay, so firstly, it's not a board resolution, but it is a letter written by Mr. Lindikaya Zide, addressed to Diale Mokhashwa, with the instructions, I think, Chair, in my view, to capitulate, because I don't think settlement is the right word. Because the instructions are, we pay everything plus interest plus costs.
Just right there, Mr. Dingiswayo, I
Yes.
want to refer you to page 272.
273,
272.
272.
Of volume 8.
Yes, this is the letter. Now, Chair, this is a letter in the hands of our opponents. I've never seen this letter, but here is a counsel acting for CIA. He has this letter. He just retrieved it from his chambers. Well, according to him. Said he has it in his chambers, disappeared, comes back, here's the letter. I have never seen anything like this. And I'm trying to now think about when this would have been. But around the same time, I came across a letter from Matopo attorneys who were saying to Diale Mokhashwa, I think it's a response, it was a response to an offer letter that was sent by Diale Mokhashwa. They say to them, those are not your client's instructions.
Can you refer to page 276?
276. Yes. Let me see.
Do you recognize that letter? It is from Mr. Matopo's offices. It's on the Matopo attorney's letterhead, and it's directed to Diale Mokhashwa Incorporated, and it's dated the 18th of December 2017. Can you scan that letter and indicate, is this the letter that you're now referring to?
Yes, let me just check. Yes, so on page 277, Chair, I was smacked by a gob. Paragraph 2 says, your settlement offers do not comply with the provisions of Rule 34. And then the next sentence, you received instructions from your client to submit the following settlement offer or tender to our client. Our opponents are telling our attorneys that this is what your instructions are. Because I think that Mr. Mokhashwa was a little bit uncomfortable with this entire exercise. And he was trying to see if he can save one bob here or there. And he didn't send the settlement, the offer, as per the letter from Mr. Zide. And when they received it, they said, this is not the offer. This is what you were instructed. How do they know that? So when Mr. Botias goes to his chambers and retrieves the letter from Mr. Zide, then clearly that letter, let me just check. Where is it again?
It's page 272, few pages before,
272.
yeah.
So this letter is dated 15/12/2017. Matopo's letter is dated 18. It means that shortly after it was dispatched to our lawyers. This is attorney and client communication. Shortly after it was dispatched, it somehow landed in the hands of the opponents. And now they are busy chiding our lawyers, saying you are not acting according to your instructions. And Mr. Bottas has the actual copy. So it was not just the content that was relayed. It was the actual instructions that were relayed.
Did you ever inquire from Mr. Bottas, where did he get the letter on page 272 from?
No.
Or did your legal representative, Bowman's, who was from the Bowman's, ask Mr. Bottas where he received this from?
No. At this stage, Chair, there was no need. It was clear. What was happening was very clear.
Did the matter then go into court that day?
Yes, we got a red eye, and the judge said, I don't see you. I mean, it was the most amazing thing. You had...
Just explain to us what actually happened in
Yes.
court.
So, Mr. Bottas hands up the letter from Matopo with the text messages from the chair. Sorry, Chair, I'm lost again in the bundle. The letter that has the transcribed text messages. So he hands it up to court. He says, these people are not here. My opponents are not here based on this letter. Now, Chair, maybe a detail that you probably know is that after the letter from Matopo was dispatched to Bowman's, they also served a Rule 7 notice. In response to the Rule 7 notice, we filed a power of attorney and attached to the power of attorney the delegation of authority framework. So in court, here is Mr. Bottas handing up the letter from Matopo with the transcribed message. And our counsel, I forgot his name, he hands up the power of attorney signed by Ms. Ngoye and a delegation of authority framework that shows that she is the one that is authorized to instruct lawyers. And the judge takes the letter and grants default judgment against PRASA. So the application brought by the CIA was successful.
What then happens?
Then we wrote to Matopo and said to them, please don't execute, we're coming back, we're going to apply for rescission. I think they took our letter and put it in a shredder. And the next thing that happened is around the 14th or 15th of March. PRASA's bank accounts were attached. 56 million that was in the bank was removed. There was pandemonium because there are two payment runs at PRASA, one on the 15th and the other at the end of the month.
Just before you continue, Mr. Tingiswayo, you
Sorry.
indicate, sorry, before you continue with that.
Yes.
You say that you then wrote to
Matop.
Matopo
Yes.
attorneys. I'm going to refer you to page 220. This is now after the court appearance of the 9th of March.
You said
20
220.
Yes, 220.
Okay, yes. Yes, 12 March, yes, that's the letter.
Is that the letter that you then wrote?
Yes.
And if, sorry, Chair. I want to refer you to page 224.
Yes,
It's yours faithfully, Fanny Tingiswayo. Did you sign that correspondence?
yes, Chair,
And it's dated the 12th of March, 2018.
correct.
And was there a response to this correspondence?
No, no, no,
You never received any response?
no.
Okay. Then, what happens?
So I was saying that the bank accounts were attached. Now, all the payments that had been processed, all the requisitions that had been processed for payment on the 15th, you're talking electricity, you're talking suppliers who have no issues with PRASA, whose payments are being processed in the ordinary course, could not be made because the bank account of PRASA's, the bank accounts of PRASA were empty because the warrants were sent to all the banks and they emptied all the bank accounts of PRASA. So, I mean, we didn't know that. We just had people talking that, what happened? We don't have money, and our suppliers have not been paid. So these are people who PRASA didn't have any issue with on their invoices. And here is a supplier that has benefited a lot, allegedly unlawfully, from PRASA. It's now having 56 million for its benefit in the hands of the sheriff.
Chair, if you can just bear with me. I want to take you to page 229.
Yes.
This is a Standard Bank, it's a copy of a bank statements from Standard Bank. You see that?
Yes.
And the account is there, and it's in the name of Metro Rail Sweeping, the branch Braamfontein, you see that?
Yes.
And there is interbank transfer, 5 million rands on
Yes.
the 19th of March to the Sheriff Pretoria, you see that?
Yes.
Right. If you turn over to page 230, it's still a Standard Bank, copy of a Standard Bank account in the name of Metro Rail Expenditure, Braamfontein. Then if you go down to the details, you will note that it's interbank transfer. It's happened on the 19th of March 2018. A sum of 9 million and some rands is taken.
There's three.
There's three, yes, I'll
Yes.
go one by one. The next one is, and that's gone to the Sheriff Trust account.
Yes.
Next one is 19 March 2018, same day, internal transfer, 18 million and some rands. And 19 March 2018, there's another one to the Sheriff Pretoria of 23 million.
Yes.
Are those the transfers you're referring to?
Yes.
Thank you. So all this happened on the 9th of March.
On the 19th,
Sorry, on the 19th of March. Sorry, my
Yes.
apologies. 19th of March.
yes.
What then happens?
So I think before the 19th, I came back to the office on the 9th with my bloodied nose and wrote to the board to say judgment was entered against PRASA. I think the detail that we left is that we had reported to the board before the 9th that there is this application for the making of the awards, orders of court, and had not received any response from the board. I think I wrote to the board, or maybe Ms. Ngoye, but one of us wrote to the board, just to report that there are these applications, and to say that the chairperson, Judge Makhubele, to ask whether the board had deliberated on these matters of CIA. Because you'll recall, Chair, that in the memo from the chairperson, Judge Makhubele, that she said that she needed the reports for discussion with the board on the 1st of December. So that was part of the inquiry, that did this happen? There was no response. So on the 9th, I wrote to them to say judgment was entered against PRASA. Again, no response. So we wrote to the minister. I don't remember when the reshuffle happened, but the reshuffle of the cabinet happened just around that time, around the 9th. And because ministers were still trying to find their ways to their offices, Ms. Ngoye called the chairperson of the board, the previous chairperson of the board, Mr. Molefe, to say, do you know how we can get hold of Dr. Blade Nzimande? We need to report this to him. We sent a report to the Parliamentary Committee, Portfolio Committee on Transport, the chairperson of the Portfolio Committee on Transport. And we found the details that could link us to the new Minister of Transport, then Dr. Blade Nzimande. And we sent a report to him about this. And then sometime thereafter, there was, the minister asked for a meeting to discuss this matter with all of us. We met in I think in the Holiday Inn down here in Sandton. And we told the minister what happened. In that meeting, Judge Makhubele, because there was a lot of exchange. It was a little bit heated at some point. So Judge Makhubele made a proposal, which I think was sensible, that we should write reports. Instead of sitting in a meeting and telling the minister what happened, we should write reports, and we agreed that Ms. Ngoye and I would write our report to the minister, and she would write her report to the minister. And the minister gave us until the 16th of March to submit those reports. The reports were submitted. Sorry, our report was submitted. We compiled it, we got a file with all the supporting documents, and we gave it to the minister's chief of staff, and he went away. And around the beginning of April, the minister gave instructions for us to recover PRASA's money. So in the recovery process, what we had to do is a two-step process. First, we had to interdict, we wrote to the sheriff to say, please don't pay over the monies that you've attached, because this is what we intend doing. He said, I cannot not pay over without a court order. So we went to court, applied for an interdict, so that the sheriff doesn't pay over the monies. And we had a part B of that application, which is now the rescission. We got a call from CIA's lawyers. They asked if we can agree to an expedited hearing of the rescission. So they say they'll concede to the interdict. We must agree to an expedited hearing. We said, no, we're not trying to delay here, by all means. So we went to court on, I don't remember when, in April. And the matter was, then the agreement was recorded that we'll approach the deputy judge president for an expedited date, agreed on a timetable, we're granted the date, and we're supposed to supplement our papers in the rescission. So we did supplement timeously, and then we waited for CIA to respond, to file an answer. No answer was coming. So we waited for the hearing date, and with no answer, we got there. The court granted the rescission. Yes, I'm at 343.
At the bottom, there's an email addressed to yourself from Veronica Malangeni.
Yes.
And it's an email with regards to the writs, Sorry, jeez. I'll start again. Page 343. It's an email from Veronica Malangeni. It's addressed to yourself. The subject matter is CIA writ of execution, 4 different cases. Dear boss, please find attached writs with regards to CIA different matters. Regards, Veronica. Then on the 15th, it's 2018-0315. Which would have been 15th of March 2018. You see that with other numbers?
Yes.
And there was an attachment, right?
Yes.
If you go up on that page, you'll have to go eventually to page 342, the page before.
Yes.
And you write to Mr., that's your email now, yes, to Mr. LK.
Yes.
Lindikaya.
Yes, that's Mr. Lindikaya Zide.
What were you saying? Just paraphrase that. What were you saying to Mr. Lindikaya in that email?
So I was just reporting to him that we hear the warrants, and and that the time that the lag in the decision making has now caused this situation. And I don't remember where I got this sense that Mr. Molepo is aware of the warrants, but I say that in the email. And I asked him to bring these, because at this stage, Mr. Zide was the company secretary. So I asked him to bring the warrants of execution to the attention of the board. And I indicate that this may have implications for them, the members of the interim board. I mean, the company secretary is an advisor to the board. So I'm just saying this is my view. I mean, I just talk to the people in the interim board to see. I mean, if he agrees with me, then they would know that this may constitute financial misconduct by them. And Chair, I think here I was referring to the criminal financial misconduct that's provided for in the PFMA, the Public Finance Management Act. So there's criminal implications to that. So, and at this, on the same day, I had received an email from an organization called Equal Education. Around this very matter. So I said that I'll need to know how to respond to that email, because if my memory serves me well, they had demanded that we should indicate that we would not pay, or that we will have those the judgment reversed.
Mr. Tingiswayo?
Yes.
You also indicated to us a few minutes ago that you had written to the sheriffs requesting that they do not release the money.
Yes.
I want to refer you to page 344 of volume 8.
Yes. Yes, sorry.
Sorry?
No, I'm saying this is a letter from Edward Nathan to
The sheriffs.
the sheriff, yes. So, I mean, this is the mess that was created by that resolution of 1 December. If I remember well, Edward Nathan was briefed on the basis that it was on the SACA panel by Mr. Molepo. So I mean, I think it's interesting in a number of ways, but maybe let me just mention two. The one is that Mr. Molepo was part of the settlement. I mean, he was pushing for it. Now, here he is acting in this manner. That's the one. The other is that, which we pointed out to him, is that Edward Nathan was acting for Swifambo in the review application for the for the locomotives tender. And Mr. Mabunda was alleged to be involved in that transaction. So he said, Edward Nathan is conflicted. And I think this also is exemplary of leaving people who are not in the legal department to do these things. He said, Edward Nathan is conflicted because we know that there's an alleged relationship between Swifambo and Mr. Mabunda. So, but I mean, this is, yes, this is the letter.
So was ENS appointed as a result of this, following the SCM processes?
I have no idea.
You have no idea?
I doubt though.
Okay. Now, Mr. Tingiswayo, are you aware that the chairperson, Judge Makhubele, resigned from PRASA in March 2018?
Yes, it was a resignation. I think we only learned of it the following week. I think it was effective from 16 March.
March, yes.
Which coincided with the day that she had undertaken to give the minister a report on these matters.
Okay. And this was after the matter in court?
Yes, now they have judgment, the warrants have been issued.
Thank you. Chairperson, may we take the lunch adjournment and resume at 2 o'clock?
We'll take the lunch adjournment and come back at 2 o'clock.
Thank you. Thank you, Chairperson and the members of the tribunal.
Yes, just to remind the witness, you're still under oath?
Yes, Chair, thank you.
Yes.
Thank you, Chairperson. I have no further questions for the witness.
Happily, it is Mr. Happily, Chair, it is going to be Mr. Salugazana who asks questions.
Good morning, Chairperson. It's Mr. Salukazan. Good morning, Mr. Tingsai.
Afternoon.
Oh, good afternoon. I beg your pardon. Thank you. You don't have any evidence that Judge Makhubele is corrupt, do you?
You seem to be taking your time.
Chair, it's an interesting question. And it's interesting in the sense that Judge Makhubele worked very hard.
Chair, may I come in here? I've asked a simple question. Please answer it. Do you have any evidence that Judge Makhubele is corrupt?
Judge Makhubele worked very hard to further the interests of CIA. And CIA is implicated in a lot of corruption within PRASA. So I'm not in a position to either say she is implicated or she is not. But the manner in which
Yes.
the manner in which she worked hard, Chair, Judge Makhubele started working on this matter on the 14th of November, 2017. By 21 December 2017, she had settled it. CIA failed to get this matter, to give this matter any traction from the time they instituted the action up to the time that she came. And then after she left, CIA failed again to give the matter any traction. They didn't oppose the interdict in any meaningful way. They didn't oppose the rescission application in any way. To date, they have never progressed this litigation. Now, the question that arises from all of that is why it is so. And I would be loath to say to this tribunal that I can say for certain whether she is implicated or not. I can certainly say that the manner in which she worked hard shows that there was a pressing motivation on her and nobody else to get this over the line.
Do I understand from that answer that you gave, you can neither say yay or nay, but the explanation is, in your view, that over a short period she seemed very intent on advancing the interest of CIA. Would that be correct?
That is correct.
And that's about all you can really say?
That is correct, Chair.
Yes.
If there would be a contest between Judge Makhubele, Mackenzie Mabunda, and say Lindikaya Zide, on who worked the hardest to get these things over the line, Judge Makhubele will win that contest hands down.
Yes, thank you. You may put the next question.
By the way, what do you mean by working very hard? Could you just expand on that, working very hard?
Chair, I think we've
It sounds like a person who's very honest and diligent and
oh.
taking their work seriously, etc., etc.
Thank you, Commissioner. I didn't contemplate that meaning.
No, I just want clarity.
Yes,
of
yes,
what
I
you're
understand.
saying, that's all.
Yes, so I'm saying that she put a lot of effort, more than anyone else who's ever touched any of these matters, even the plaintiffs themselves, to make sure that these are settled, and, you know, to, when the settlement was challenged, she was again the one in the forefront to frustrate the challenge of the settlement.
Thank you, Chairperson. We will submit that my question was, do you have any evidence? The witness then stated that he can't say whether or not Judge Makhubele is corrupt and was not answering the question, and that there is no evidence before this commission that she is corrupt. I'll move on to the next topic. Do you agree
Well,
that...
just before you go on, you can't comment upon the nature of the evidence. That's for the tribunal to say. You can only say or try and encapsulate what the witness had to say. You can't pass judgment on his evidence as such. What you can say is that he certainly wasn't prepared to express an opinion as to whether or not Judge Makhubele was corrupt. But he had the following, and we had his explanation.
Indeed, I
to
stand
say, yes.
chastised. Do you accept that it is the minister who appoints a board of control at PRASA?
Yes, and that's according to the Legal Succession Act.
Once the board is appointed, it cannot be that the chairperson is blamed for the legality or illegality of the composition, correct?
Well, if I'm speaking for myself, I would be very uncomfortable sitting in a board that is not properly constituted. Sorry, Chair. I would be very uncomfortable, Chair, sitting in a board that is not properly constituted. Simply because the challenge to any decision that that board takes is very easy. So before you look at the merits of a decision that they have taken, you then say, were they properly constituted? And if the answer is no, the question is, were they therefore empowered? So it looks like it's a waste of time for me to sit in that board. Of course, you don't appoint yourself, but once appointed, once you understand that there is this challenge, I believe that it is incumbent on the person appointed to make sure that they don't waste time and money and make decisions that will be easy to challenge.
And the challenge would lie as against the minister, correct?
It will lie against a decision that they've taken. So they take a decision, there's a big tender to be awarded, 5 billion. They take a decision, they award that tender. The losing bidders come to court, they say, we want to challenge this award. And they say, the first point of challenge is that this award was made by a board that is not properly constituted.
I'm still at the appointment of the board, and you agreeing that it's the minister. The challenge to the composition of the board would be against the minister's decision, correct?
Yes, so if you want to challenge the appointment of a board that is not properly constituted, you cite the minister. But the example I was making is if you want to challenge a decision taken by the board, and that is why I'm saying by sitting in that board, you are wasting resources, You may be wasting time. You are being paid for doing work that may be easily assailed.
Thank you, Mr. Dingiswayo. Are you in private practice at the moment?
Correct.
Do you do any business other than legal businesses?
Yes, I do other businesses.
Did you do any private business whilst you were at PRASA?
Yes.
Okay. Did any of the business or business people you were associated with do business with PRASA?
No.
Okay. May I ask the tribunal and you, Mr. Dingiswayo, to turn or at least pull up volume 29? That's 29. 29. Just for the sake of convenience to the evidence leader and the tribunal, the documents I will refer to were provided this afternoon. I'm not sure that you received them. No, it came this afternoon. It's on the table. I see the president
Just to get clarity, we have the bundle. I just want to know, have they given it to you as well?
Yes, yes, Chair, they have.
Yes, okay. Yeah.
May I ask that you turn to page 96?
I'm at page 96.
The Auditor General found that a business partner of yours was doing business with PRASA. Is that correct?
Where is that?
No, it's a general question. I'll refer you to where I'm going. Answer my question, please. The Auditor General found that you or a business partner of yours did business with PRASA. Is that correct?
No, Chair, may I be led to the finding? Let me be shown the finding before because what this document is it's an inquiry. It's not a finding.
Well, as I understand the question, has there been a finding that while you were at PRASA, a business partner, as it has been put, had business with PRASA? Has there been such a finding as far as you...
I'm not aware of it, Chair.
Yes.
Okay.
Are you, just to complete the question, are you aware that an allegation may have been made that's directed at you, that a business partner of yours had been doing business with PRASA?
Yes, Chair.
Has there been such an allegation?
There has been.
Yes.
Chairperson, if I may then direct Mr. Dingiswayo to this page 98, specifically at page 100, and the table starts at page 99. It is entitled Annexure C, and as you will see at page 96, it says Annexure C is with regard to business partners of PRASA employees in another entity doing business through a different entity, doing business with PRASA through a different entity. At page 100, I wish to refer the witness and the tribunal to item 18. And I put it to you, Mr. Dingiswayo, that the Auditor General did find that you were one of the employees at PRASA whose business partners were doing business with PRASA. Do you accept that?
Let me see if I can be of some assistance. Let's look at 18 on page 100 of volume 29. Have you got that?
I have, Chair.
I think what council is referring to is, it would appear that the name Dingiswayo Senior appears in the fourth last column. Do you see that?
Yes, I can see my name, Chair.
Yes. Now, I take it, do you know what this is all about?
No, Chair. The only Pilato I know, Chair, is Pontius. I don't know any Samuel Koza. I don't know anything about this company. And the reason, Chair, I was going to the issue of a finding against me is because the normal way that the Auditor General works when they're going to find something against you is they give you the suspicion, they ask you to comment. If you look at any Auditor General audit report, there's something called management comments. And management comments say whether you agree with the finding, the finding that the Auditor General is contemplating or you don't. And if you agree, it's confirmed. If you don't agree, they might still make a finding. So that never happened. So the AG never approached me to ask me whether I know Pilato Technologies, whether I know Mr. Magezi Samuel Koza, and therefore they couldn't have never made a finding against me. This letter was addressed to Mr. Peter Malele, I can see. He never shared it with me.
Okay. Thank you, Chairperson. So if, now that we've pointed out that you were listed as a person whose business partner was doing business with PRASA, did you?
No. He wasn't listed at all. He's just explaining what he sees is the meaning of all of this, and he doesn't know Pilato Technologies. Am I correct?
That is correct, Chair.
Yes.
Chairperson, okay. Go to column, item 18 at page 100, column 1, 2, 3, 4, 5, 6, 7. Are you the Mfanimpela Tingiswayo listed there?
Yes.
Do you accept then that you are listed there?
Yes, my name appears on that list.
Yes.
Yes.
Did you ever challenge the listing of your name as an associate of Pilato Technologies?
I don't know what happened to this. So this document is asking Peter Malele to confirm whether there was for Annexure C, follow up if the employee declared interest. That's what they're asking him to do.
Yes.
And recuse themselves from the awarding of the contracts. I've never sat on any bid evaluation committee whilst I was working at PRASA. Follow up if the supplier have declared the interest. I don't know. I don't know what Peter Malele did with this document, but there was never a finding against me. Well, that I'm aware of.
Indeed. So do I understand you to say that this was addressed to Mr. Peter Malele and he was meant to follow up with you whether or not you knew Pilot Technologies?
I have no idea what he was going to do with it.
Okay.
I see what is written, what they're asking him to do. I don't know what he did.
No, certainly. And
Yes.
my question wasn't what he did, but what the letter requires of him.
I've said that, I've read that into the record.
Thank you. Now let's go to the appointment of the interim board led by Judge Makhubele. And primarily, I will be referring to volume 8.
8. Who are you?
Please let me know when you're there.
I found it.
Please go, when you're at volume 8, to page 18.
1-8.
1-8.
I am at page 18.
Go to paragraph 42.
I am at 42.
Did you attend the meeting that Ms. Ngoye says took place on 9 November?
Yes, yes, sir.
Do you accept that the chairperson raised, amongst other issues, the worksman's attorney's investigation?
Yes,
Am I correct then that at that meeting, she did not go directly to the CIA matters in the litigation? She also raised other issues.
I don't think in this meeting CI was ever raised. Remember, according to her memo, she was approached on the 14th of November. That's after this date. So she would have not, according to her memo, she was not involved in CI at this point. She was just asking about how are we working. I think she asked us if we were acting or in our positions or not. You know, it was an introductory meeting. So CI didn't feature. I suspect because she had not been approached.
Yes. And then on the 14th, Ms. Mayangoye,
Martha.
Ms. Martha Ngoye met with the chairperson again, correct?
I think so. Yes, I think this is what she says in this affidavit at 43.
Chairperson, because of the response, I wish to refer the witness to his affidavit before Zondo Commission, where he stated, as a matter of fact, and that you will find at volume 10, page 37.
Yeah, it's here. I think this is 10.
The witness says he thinks there was a meeting on 14 November. I want to put it on the record as a matter of fact, referring to his affidavit. And at page 37, paragraph 41.1, the witness says, first, on 14 November 2017, she met with Mayangoye to inquire about cases involving CIA. Following a request from Ngoye, I asked PRASA's then attorneys or lawyers in these matters to prepare a report.
Yes, I see that. Thank you for the reminder.
So as a fact, you know that there was a meeting with Ms. Ngoye on 14 November.
Yes.
Then, as you set out in that affidavit, I wish to refer the Commission to the report that was prepared by Diale attorneys. That is at volume 8, page 233. It's a report of 21 November. Volume 8, page 233.
Yes, Chair.
Have you seen this report before?
Chair, I've answered this question. It was sent to me. I read it. I checked that whether it was correct, and I passed it on to Ms. Ngoye, and I think she passed it on to Mr. Zide, who passed it on to Judge Makhubele.
Well, now let's just deal with the question. Did you see this report before?
Yes, Chair. I have said.
You did see the report before?
Yes, Chair. I was taken through this report in chief, and I said I saw it, I checked it, I was satisfied that what is stated is in accordance with our instructions.
Yes, thank you.
Thank you. Moving from you having read the report since you saw it, this report doesn't speak to the prospects of success in the CIA matter or PRASA's prospects, does it?
I think it has enough information for anyone who is legally trained to establish the prospects of success.
since you have it before you, please point out to us where it is it addresses prospects of success.
Chair, it shows the discrepancies between the contract that was attached to the particulars of claim and the invoices. It states that PRASA is alleged to have entered into an oral agreement in relation to one of the contracts. It states that one of the contracts was partly oral, partly written. It shows that the allegation by CIA is that Mr. Mtimkulu, who's referred to in the report as Dr. Mtimkulu, who is a fraud, entered into one of the contracts. It says that Mr. Baltak entered into one of the contracts. Both of them are not authorized. It shows that, I mean, if you are a lawyer and you read, this is why I was saying that you didn't even need to take instructions from the people who were at the coalface to check whether there's a claim here. When you read the particulars of claim, they tell you there's nothing here. And this is why we instructed the attorneys to raise an exception. And this is why I said we were confident about the prospects of success. We didn't waste any time. We said, come, let's go to arbitration, let's consolidate. It was CIA was struggling. So if you are writing this report to a lawyer, my expectation, and maybe someone else might not be able to glean the prospects of success for what is clearly stated here. But my expectation really, if somebody who is a lawyer would say to me that having read this document, they were none the wiser on the prospects of success, I would be very surprised.
Do you remember what I asked of you?
Yes.
Please point to the document where it is they address prospects of success.
I think you've got to be fair to the witness. He is simply saying that the whole tenure of this document, as it speaks to him as a lawyer, is an indication that these matters were problematic for the plaintiff, as I understand his evidence. But he will not be able, because I couldn't find it, point to the words that you are asking him to refer to. I don't know if those words are there. If they are, you can put the words to him. Or if they're not there, you can say that the document doesn't say that there are no prospects of success, and it's up to us to decide.
Certainly, Chairperson, or at least President, I am building up to that. I'm placing facts to him. I can't just make the proposition. I've asked a question. The question was not answered. Just like the Chairperson has said, you can't find it. So all I want from him, and I will put it to him, if he says there is or there isn't, may I be allowed to build the facts before I put the proposition?
Well, you can put the question to him that nowhere in this report is there mention by the writer thereof that the cases brought by CIA is meritorious or non-meritorious, whichever word you would like to use.
Yes. Having failed to point out, I put it to you that there is nowhere in this document where Mokhashwe attorneys speak specifically to the prospects or the merits of the case. Do you accept that?
I accept that you will not find a sentence that says, under case 73934 of 2015, PRASA's prospects of success are good. But
Or bad?
Chair, yes, or bad. But Chair, I've also said that if your audience are people that are legally trained, you would expect them to glean from this report whether there's merit or not. I mean, on my own, I didn't need this report. Having read the summonses, I came to that conclusion. Had I not believed that we have good prospects of success, we wouldn't have instructed lawyers to deal with these matters. So if the version of Judge Makhubele is that she could not glean that from this report, that's the version.
But you say you gleaned from the report that what the lawyer is intimating, that there are problems with the plaintiff's case in this matter.
Yes, Chair.
Yeah.
I knew them. So the information was not new to me. I knew from the summonses themselves. And I would expect any lawyer to see from those documents.
In fact, what you would have expected would be for the attorneys of CIA amend their papers to suit their claim.
Yes, that's why I said that they didn't amend all the way. We're discussing trial dates. They've not done anything to their pleadings. But Chair, I think that my reading of Judge Makhubela's version is that she emphasizes on what she calls major concessions as the reasons for asking why are these matters proceeding. She's not asking, when she responds to this, she does not say, you have not told me that there are the prospects of success. She says, you have not told me that how are you going to deal with the major concessions that were made by the employees of PRASA. I understand that to be the nub of her contention in the memo that she writes, responding to this letter.
And Chief, you said that you had taken exceptions and those exceptions were dismissed, correct?
Correct.
So the errors that were so obvious to you were also not obvious to the judge, correct?
No, that's not what it means. It means that the judge did not believe that we could not plead. So the judge believed that, because remember, when you raise an exception, you're saying if they don't remove the cause of complaint, I can't plead. So the ruling says that, the ruling means that, no, you can plead. So go ahead and plead, which we did.
I also understand it to mean, and I'm going to put this to you, that a cause of action was set out in the POC, correct?
No. I understand an exception to mean that you are saying, if you don't remove this cause of complaint, I can't take the matter further. It does not mean that you have not, there's no cause of action, unless the exception is there's no cause of action. But here you've got a vague and embarrassing particulars of claim. So in that case, the ruling means, no, go ahead, file your plea. And we did.
So you didn't take a challenge to the fact that they didn't disclose a cause of action in your exception?
I don't remember.
Okay.
But I mean, remember, what I'm raising is the vagueness, the contradiction between the invoices and the contract. That is vagueness.
Okay, I'm not going to argue with you about what, when you attach a different agreement to what you're claiming, that means. We'll make submissions to the tribunal. May I ask that you turn to a memo from Judge Makhubele. It's at page 24. Once again, we are at volume 8.
24.
248, I beg one. 248.
I'm at 248.
Paragraph 1 says, I refer you to various discussions between us about this matter, as well as our brief discussion with the Group Executive Legal, Risk and Compliance, Matangoye, which took place on the 14th of November 2017. You confirm that these did take place, correct?
Yes, again, I confirm.
Let's move then to paragraph 5, which is at 249.
I'm at 5.
It reads, you are aware that attorneys acting for CI consulting engineers, open brackets, in liquidation, close brackets, approached on or about 14 November, and that they provided me with a copy of an interim report of the inquiry in terms of the Companies Act that was prepared by the Commissioner and dated 15 September. Let me stop there. Do you accept that Judge Makhubele did mention to you and Ms. Ngoye and Mr. Zide, well, I suppose let me speak about what you knew. Did you know at this stage that Judge Makhubele had received a report?
No. This meeting was with my boss and Mr. Zide. But there's that 14 November. Remember, we're talking about the 9th November.
Yes.
That she didn't know on the 9th, on the meeting of the 9th. So she only was approached on 14.
And Ms. Ngoye met with her on 14, correct?
Yes,
Ms. Ngoye didn't tell you what Judge Makhubele told her at the meeting on 14.
she told me.
But she left out that Judge Makhubele had been approached by the attorneys, as you've just now stated.
No, she didn't leave that out. She told me. This is why this report that we are talking to was drafted. Because there's an interim report. In the interim report, major concessions were made by PRASA employees. So please ask your lawyers to prepare a report for me on all these matters.
Forgive me. This memo is dated 28 November, right?
Yes.
Ms. Ngoye told you about the meeting she had on 14 November, before 28 November. Am I missing something?
No, you're not missing anything.
So my question then, which says you were aware of what is set out in paragraph 5 when you received this report. By 28 November, let me put it differently. By 28 November, you knew of the discussions that Judge Makhubele is referring to here. Yes or no?
Chair, I've given evidence about this. I've said that there was a meeting. After the meeting, I was told what happened at the meeting. And what is appearing in paragraph 5, which was read into the record, is what I was told. I don't think maybe I don't think the date was there in the report, but I mean that entire I don't think the dates were in the report. Sorry, that Ms. Ngoye gave to me. But whatever counsel read into the record on paragraph 5, I was told, and this is the reason why we then requested the report from Diale Mukhashwa.
Sorry, which date are you?
I'm saying the
The
dates
date of
that
the
are
writing of this
reflected,
memo or the date that appears in paragraph 5? Yeah.
the dates that appear in paragraph 5. I'm saying when Ms. Ngoye was giving me the report on what she discussed with the chairperson, I don't think those dates were in her report. That this is the date of approach and that this is the date of the report. But what she said is that Judge Makhubele has an interim report that was given to her. In the interim report, major concessions have been made by former and current PRASA employees, and she would like us to prepare a report for her on these CIA matters.
At paragraph 7, at page 250, that's 250, the report reads, "It is clear from the interim report of the Commissioner that the witnesses that testified at the litigation inquiry include former and existing employees of PRASA. These witnesses would have attended the inquiry with your knowledge and understanding of the evidence that they were going to tender." Do you confirm that there were PRASA employees that were subpoenaed to the inquiry?
Yes, Chair, I've testified about this. I gave the names. They are there in 9A, B, and C of the report on page 251.
These were employees who were involved in the performance and execution of the contracts under which CIA was allegedly claiming.
No, these were the employees that were subpoenaed.
Were they involved in the execution of the contracts?
No, they didn't know about them. All of them said they don't know about them. I mean, their reports are here. All of them are saying, I don't know anything about this. I don't know anything about these invoices. Except for Baltak, who says there was a contract, services were rendered, but we don't know how much to pay. So you ask yourself, is there a contract when you don't know how much to pay? What is in that contract? How come there's confusion about what is payable when there's a contract?
Was Mr. Baltic one of the people who were subpoenaed?
Chair, I've said again that the people that are subpoenaed are appearing at paragraph 9, A, B, and C. At C, there is Mr. S. Baltic. I think the spelling is wrong. It's B-A-L-T-A-C.
At the risk of being accused of being unfair to you, I ask simple questions that require yes or no, and you go into explanations.
No, what he's simply saying is paragraph 9 sets out the names of the people that were subpoenaed. The name Baltic, as it appears there, doesn't quite fit in with what he understands how Baltic is to be spelt. Am I correct so far? That you say it should be spelled B-A-L-T-E-C.
T-A-C.
T-A-C.
Yes, Chair, you're correct. I mean, there's an email from him,
Yeah.
and there's a report from him. It's an A, not an I.
Yes,
But the point I was making, Chair, is that I have said that.
yes.
I'm repeating myself probably for the third time.
Chairperson, at the risk of being chastised by you,
Yeah.
I'm at paragraph 7. I've not reached 9, and I'd like the witness to allow me to ask my questions.
Well, you've asked it and he's answered. What more do you want him to do?
An answer that is limited to my question.
Yes, he's limited to your question. He says, there it is.
I'm at paragraph 7, Chairperson.
Yeah.
Yes. Moving on to paragraph 8. Are you there?
Yes,
It says, should the contents of the Commissioner's report be correct, it is clear that the witnesses made major concessions with regard to the liability of PRASA in civil actions launched by CIA Consulting Engineers, again, open bracket, now in liquidation, close bracket, full stop. However, despite these concessions, Mokhashwa Diale attorneys appear to still want to proceed with the arbitration proceedings. Let me stop there. Do you accept that the chairperson is not stating as a matter of fact that the concessions were made?
Sorry, repeat the last part. Does not state as a matter.
The chairperson is not saying the concessions were made, correct?
It does say.
Let me put it a different way.
She says the report.
Yes.
Yes.
And she's not saying that the matter doesn't have any prospect. She says if the concessions are correct, or at least the report is correct, then the Yalo Mokhashwa should not be defending, correct? It's not a conclusive statement, is my proposition to you.
Yes, but I think the chairperson is leaning more to, Judge Makhubele was leaning more towards the correctness of the major concession. And that is why she says, however, despite these concessions, and I'm not sure why she's blaming poor Diale Mokhashwa, but she says, however, despite these concessions, they still want to proceed. So she's not neutral. She's not. She thinks that there's some merit to the concessions.
But this paragraph is not conclusive or leaning towards anything. It is conditional. Do you accept that?
No, my evidence is that it's leaning towards the correctness of it's not neutral, it's leaning towards the correctness of the conclusions.
Okay. And then the last paragraph, or least sentence of the paragraph, says, they, however, did not address the prospects of success at the arbitration proceedings in view of the evidence that has already been led in the litigation inquiry. Again, at the risk of being chastised for repetition, you agree that the 21 November report does not speak to prospects of success expressly?
No, this is why I was saying earlier, Chair, that the Judge Makhubele's contention is not about whether the report shows prospects of success. She is saying these concessions, there is no indication of the prospects of success. It's qualified. She says, in view of the evidence that has already been led at the liquidation inquiry. So it's not an absence of prospects of success in the document, it's absence of prospects of success in view.
Thank you. I'll move on now to your paragraph 9, and you'll confirm that the reports were requested from those people.
No, it's not mine. It's not mine.
Do you accept that paragraph 9 requests testimony or reports from the 3 witnesses that attended the inquiry?
Yes, Chair, it's there. It's in black and white. It says exactly that.
Okay. And then if you could go to 254.
I'm at 254.
At the bottom of the page, there's an email from Fanny Tingiswayo to Vincent Kobuwe and Soren Baltic. This email was sent having received the report from Judge Makhubele, correct?
Yes.
And you requested the report from Mr. Baltic and Mr. Kobuwe, correct?
Yes, Chair. And there's Baltak with an A.
If you can then turn to page 257.
57. Yes, I'm at 257.
This report, if we go to 258, is from Mr. Soren Baltic. Is that correct?
Yes, with an A.
Mr. Baltic, in the first sentence, says, this report has been requested by the chairperson of the interim board, Advocate TAN Makhubele. The next paragraph, CIA consulting engineers, defined CIA, have been appointed by PRASA as technical advisor and supervisor, I imagine it's supposed to read, for Gauteng 1 resignaling project, Gauteng 2 resignaling project, and radio digital railway signaling network project known as GSMR project. Makenza Mabunda was in leading CIA. I, the undersigned Soren Baltic, was charged by PRASA to direct these projects. Do you confirm that Mr. Baltic was indeed charged by PRASA to direct these projects?
No, that's what he says. I don't have qualms with it.
Okay. Then we move on to the sentence starting in essence. Do you see that?
Yes.
Mr. Baltic says, in essence, I have been asked by the commissioner, that's the commissioner of the inquiry, do you accept that?
Yes. Yes, Chair.
To answer to the following 3 questions regarding the resignaling project. The first question, numbered 1, did CIA fulfill their contractual obligations? I ask that you move on then to, under my answers to these questions. The answer to the question, did CIA perform the contractual obligations, reads, yes, in my opinion, CIA fulfilled their obligations before entering into liquidation. Please confirm that the letter indeed says that, or the report says that.
Sorry, what must
Do you confirm that the report at my answers to these 3 questions at number 1 says that CIA had performed its contractual obligations?
Yes, Chair, that's what he says.
Thank you. The second question, have CIA been remunerated for the work done? The answer: I was aware that there were instances when CIA have not been paid for their work done. Do you confirm that that's what the report says at number 2 as an answer?
Indeed.
Number 3, if there is any payment outstanding towards CIA, SLR produced a list of CIA unpaid invoices. The answer is, I need to look in the file and consult with my colleague, Johan Edwards, the chief engineer signals, in order to come with a reliable response. Do you confirm that that's what the answer is to whether or not payments were made?
Yes.
So he doesn't state that payments were indeed made in this report, at least.
No, he says he'll check.
Okay. Then he says, furthermore, the SLR, through the commissioner, asked if I know if there are any...
Sorry, Chair, are we in 258 now?
We are in 259, I beg your pardon. Just scroll.
258?
8, I beg your pardon, sorry. Furthermore, do you see that paragraph?
Yes, on top, yes.
The SLR, through the commissioner, asked if I know if there is any outstanding payment to CIA for the GSMR project, why and what is the value of the outstanding amount. My response was that there is an outstanding payment for a variation order. Do you confirm that Mr. Saubek, in his opinion, Baltic, in his opinion, says that there were outstanding payments owed, at least to CIA? Do you confirm that that's what he says?
Yes, he says there is an outstanding payment.
Indeed.
Yes.
And then the next sentence says, CIA have been asked to assist PRASA to get the most effective deal for the extension of the GSMR project. The decision for payment has been stopped at higher levels in PRASA due to different opinions regarding the rates charged by CIA's German expert working on the project. In my opinion, the value of the VO needed to be revisited and agreed. The next paragraph. At the end of the inquiry, I have been asked by the Commissioner to check with Mr. Johan Edwards the outstanding amounts for the resignaling project and to confirm what value for these outstanding payments and to revert in a week's time. Do you accept that throughout this report, Mr. Baltic is of the view that there is money owed to CIA? There's outstanding amounts, even though not calculated at this stage.
No, he's saying two things. He's saying there's an outstanding payment, and he's saying that he's suggesting that, well, he's saying something that implies that the rates were not agreed, because he's talking about someone not happy where he says higher levels, and it seems he agrees with that, because he says, in his opinion, the value of the VO needs to be revisited. When I see that, I ask myself, where's the contract? Chair, this is an engineering project. The ordinary costs, when you do a variation order, you get an instruction from the client, which is PRASA, to say, this is what you had designed for me. I want to change this. The first thing that you need to submit is how much is that change going to cost me? What is going to be that change, and how much is it going to cost me? After you have agreed on those two issues, then you get an instruction to proceed with the variation. And when you proceed with the variation, it means you are going to do the work that is specified in the variation order at the price you specified. So that is a variation order. So if Baltic is saying, higher up is not happy with the rates, and I think, as the project manager, that they need to be revisited and agreed, the question that comes to my mind is, where is the agreement Remember, the claim in relation to this is based on what they say an agreement was concluded between PRASA, represented by Baltac, and CIA. I don't know who was their representative. So the question is, where is that agreement? Before even you talk, if you don't have rates, what is that agreement? How can you say you have an agreement, you have a variation order, when you don't have the rates? So this is why I said earlier that Mr. Baltac is in trouble. He has given instructions to CIA when he was not authorized to do so. They have probably, and they know, because CIA knew PRASA very well, they know he's not authorized. Then they submitted an invoice. Now, Baltac doesn't have a contract, so that when he submits the invoice, he must attach it to a contract and say, there's the contract, there's the invoice, please pay. So he's sitting with a problem. And this is exactly what he's saying here.
So the VO has to be agreed and becomes part of the agreement.
Yes, it's normally an addendum. So you have a project plan, you have a design, you have rates, everything. And then you did not know that as you're digging the foundation, you find out there's a rock that you need to deal with. So that's a view that maybe the contractor will initiate. But then at the end, where you say, I have now a VO, a variation order. It's an order, purchase order, variation order. You have what must be done and how much it costs. So my question from this is, where is the variation order?
So no variation order, no invoice to be paid.
Yes, this is what Baltac is sitting with. He's got an invoice. He doesn't have a paper to accompany the invoice to finance. Because the other thing is that, remember, all these projects are budgeted. So when you do that variation order, you have to now increase the budget on the other side, so that when the invoice hits the system does not say you've exceeded your contract value, because now you've amended it.
So until such time, PRASA doesn't owe CIA.
No, Chair. So what I'm saying, Commissioner, is that I would like to see this variation order where you still need, which has an invoice, but you still need to talk about rates.
Mr. Tingisai, you're under cross-examination. What's your final answer to the question posed to you by counsel for Judge Makhubele?
Sorry, Chair, say that again?
I could hear you explain a lot of things. What is your answer to the question posed to you
No, Jay,
by counsel for Judge Makhubele?
all he was asking me is to confirm what he's read. I confirmed it. He's read it into the record. I've confirmed it. But I then explained, because it's part of my earlier evidence, to say that this is where we are now is the reason I said what I said earlier about this report.
Mr. Tingiswayo, I ask that we limit ourselves to what I ask and what is set out in the report, because my question is, what does the report say? Don't anticipate what I want or whatever. I just ask, again, I'm going to be chastised for it, but I want it on record that that's what I asked you.
I confirmed what you read. I mean, you read it very well, and I confirmed that it is what you read.
Okay. President, may I ask for a comfort break and take instructions from the judge about how we should go forward, at least in respect of this particular matter?
Yes,
Indeed, that would be sufficient.
We will stand down for 10 minutes. Yes, Mr. Salukuzuma, you may proceed.
Thank you, President. Mr. Tingiswayo, now that we've addressed Mr. Baltek's, please forgive me if I mispronounce it, I'm not as fluent as you are. I'll take you to the transcript, which is at volume 16 of 1. That's the transcript of the inquiry. The page is 262. That's correct. 16 of 1, yes. In chief, you said this inquiry was a sham, correct?
Apologize, Chair, I had not switched on my mic. Yes, I believe so.
When did you realize it was a sham?
When I realized that Matopo Attorneys was acting for CIA in the inquiry. I don't know what are the outcomes of the inquiry. It looks like, from what I know, and maybe there's more, Chair, but from what I know, PRASA employees and former employees were some subpoenaed. No documents were prepared for PRASA employees. They were given some invoices. Kobue says, I don't know this invoice. They give him another set. He says, I don't know. They realize he can't, they can't do anything. But they subpoenaed him. I'm not sure what Vermeulen said. I would have expected, sorry, Chair, maybe I passed quickly the first point. I would have expected that in an inquiry, Matopo Attorneys represents the directors of CIA, they're not participating in the inquiry. I don't remember where I read a strange thing that I think the master set up the inquiry. I think it's in one of the memos from the chairperson, from Judge Makhubele, and prepared a report for the master. So the master chaired the inquiry and prepared a report for himself. So up to today, I don't know what happened of this inquiry. You would have expected that there is Mr. Kraus, who was the liquidator's attorney, takes a lead, and the inquiry focuses on the directors. Now, the directors would have been the ones who instructed Matopo Attorneys when the litigation started. My understanding is that a 417 inquiry, one of the things it does, it looks at the conduct of the directors. Now, when you have the same lawyer who was instructed by the directors running the inquiry, then the focus is not on the directors of the company. I expected a lot from this. About $1 billion went into these companies, and they went into liquidation. Was that money used for purposes of this company? Were these companies just a conduit for money between PRASA and the shareholders. So I expected summonses to be flying out to the directors and asking for accountability.
Perhaps we will proceed a lot quicker if you listen to the question and just answer the question. I appreciate you know what went on and you want to explain, but please just direct whatever answer you have to the questions that's asked of you. If we want explanations, we will ask for explanations, and then you can tell us what it is that you want to say. But for now, just answer the question as best as you can, if I may put it that way. So,
Thank you, Chair.
yeah.
Thank you, President. Do you know the date when you realized that the inquiry was a sham? Do you remember the date?
No.
The inquiry, or at least the transcript for which we have, says that the inquiry took place on 17 or around August 2017. Is that correct?
That is correct.
And when the witnesses were subpoenaed, in chief, you said they came to you for assistance. Is that correct?
That is correct.
Indeed. So you were happy to participate or have your parties participate, or were you happy to participate despite you thinking it's a sham?
No, okay, sorry. I wouldn't have formulated that opinion before the hearing. Maybe the question you may have skipped is around what time, because it would have been around March when I receive I see the transcript, I see some of the other documents that were used in the inquiry.
Yes, thank you for rephrasing my question. So do you understand how inquiries are set up under Section 417?
Yes, we're busy doing one for Swifambo, and that was a very meaningful inquiry. Yes, so, sorry, Chair. Yes, I know.
Yes. You know that it is the master that sets up, master of the High Court that sets up the inquiry.
Yes.
Are you saying that the master participated in the sham?
No, there's something that struck me that says Mr. Grieche, the master, I don't remember, it's somewhere in these papers, set up the inquiry, chaired the inquiry, and prepared a report for the master. It seems circuitous to me.
Yes, sorry, again, I may be slow. Are you saying the master participated in the sham?
I'm saying I saw something in these papers that says that. I can look for it, Chair, if maybe council had not seen it, but it is there in the papers.
Well, what you're trying to do is to answer the question without the question being put, is why do you say the inquiry was a sham? You came to a conclusion. The question then would be, when did you come to that conclusion? Yes. And why do you come to that conclusion? Yeah. Perhaps you'd like to answer it in that way.
Yes, Chair, that was the question I was answering when the Chair felt that I was too long. And that's one of the things I mentioned about it looked circuitous to me. The second is that nothing came of it because the inquiry is there's issues around conduct of directors, and you'd expect that there's an inquiry into whether the outflows of the monies from the company were proper. So you don't quite see that. You find the focus is on PRASA, what PRASA is alleged to be owing, to be owing to CIA. Now, in an inquiry, Chair, where there's a debt, then the next question is whether that will be formulated by the report. And then the next question is, do we chase this debt or not? Liquidator, do you chase the debt or not? Liquidator calls a meeting of creditors and says, do we chase this debt? Is it throwing good money after bad? Can we afford it? If the company doesn't have money, the creditors put in money, the debt is chased. The PRASA debt, you know, if there is a debt, it was so close, Chair, we were at pre-trial, all that have to do, further and better particulars, further better discovery, hearing done. So the bulk of the money for litigation was spent. Nothing comes out of this inquiry to say, chase that debt or call a meeting of creditors to chase that debt.
I understand where you're going, but again, just to emphasize, just deal with the question. Question is simply, you are of the view that this inquiry was a sham. When did you come to that conclusion? And I think you've already explained why you've come to that conclusion, so don't explain that again.
Yes.
But when did you come to that conclusion?
After
More or
we
less.
got the documents, Chair, plus the
And when
transcript.
was that?
That was around March, April 2018.
So, yes. So I think that's what you were after, yeah.
I am Chairperson.
Yeah.
I suppose, again, I'm going to defer to your expertise, but I'll be guided by the text of the Companies Act. Section 417, sub 7, says, any examination or inquiry under this section, that is 417, or section 418, and any application therefore shall be private and confidential unless the master or the court, either generally or in respect of any person, directs otherwise. So, do you still insist that the fact that you don't know about the outcome of this report is startling or gobsmacking, as you like to say?
I think I said I'm smacked by a gob once.
Yes.
But I'm not saying what you're saying. I'm saying that I would have expected that out of the inquiry, there is an indication of whether the PRASA debt should be pursued. So if you ran the inquiry properly, you would have known that the PRASA debt is a dud. And you would then say, don't pursue it. But the other thing that is important, I think that an inquiry would have checked, as I said, the conduct of the directors, as well as the outflows of money. So that you're not just focusing on PRASA, but you're saying, how come a company that receives so many contracts went under? That is the purpose of the inquiry. And when it looks at debts, as I'm sure you would check on the section that you are reading, it says that you can look at the debts, but it's not that look at the debts for the sake of looking at the debts. Can you chase them? Are other people supposed to be paying back certain things to the company?
Because the report is final, rather is confidential, you will not have seen it, correct? Have you seen the final report, I suppose, to put it more directly?
No. I've said we haven't seen it, Chair, and I mean, it's an interesting point you raised that is confidential. It was interesting that the judge had a copy, you know.
Sorry, unlike you, I'm guided by the text, not me that says that. It's 417 sub 7, just to correct you.
Sorry, what am I being corrected on?
You said, unlike me, I seem to think that it's confidential. I'm guided by the section.
No, I was not saying unlike you said.
Yes.
I was saying what you read there
Yes,
says it's private and confidential.
yes,
So it was interesting to me that Judge Makhubele had the report.
yes. But then with regard to my question, you didn't have it, correct? The
Yes,
final
I
report.
answered your question.
So you don't know whether or not it was limited to PRASA or other debts, correct?
Yes, what I'm saying
Okay.
is you would have known if a summons is issued against Mackenzie Mabunda for saying the outflows of money, that would have been something that comes out because court documents are public documents.
Yes. Are those documents provided to you, or you have to go look for them? Are court documents that are public, as you state,
Yes.
documents that would be provided to you just on a general basis?
No, I think it's something that will come out in the open. I mean, the fortunes of Mr. Mabunda are legendary. And we even know about his kitchen units of 5 million. So it's things that are of public interest. So I'm certain that if there's a summons out there for him, unless maybe you are saying there is and I don't know it, or maybe just cross-examining not with that knowledge. So yes, I think it's something that would come out.
Yes. But you haven't gone to court, for instance, or to seek it out?
No, I wouldn't have to.
Yes.
I
Because on
didn't-
your version, it's something
I didn't
that does
have
come
to go anywhere to find out he's got 5 million worth of kitchen units.
Okay, that's correct. So then, now that we've exhausted your conclusions that it was a sham, I would like to ask you that, are you saying that the people who participated, and I will list them at least as they are summarized in this report, Mr. Portis SC participated in the sham?
Yes, I think so. I mean,
You're saying that Matopo attorneys participated in the sham?
I think they were conflicted. If it was a yes, I think so. Sorry.
Yes.
Yes.
Thank you.
I think I'm going back to the reason I provided for the answer. I apologize, Chair. I think so.
Yes, thank you. And you're saying that the commissioner was appointed, Mr. Krecha, participated in the sham?
I said there's a strange thing about, and I don't know who was the master at the time. I probably need to find this because it says that Mr. Krecha appointed, did this inquiry, and then after the inquiry was set up, he made a report. They say it says Mr. Krecha, the master, or something like that.
Well, we don't have to go into who held the inquiry or why it was. Just follow the question. The question is, you say you came to an impression that the inquiry was a sham. Now, what's being put to you is the people who participated in the inquiry were all participating in a sham, and I don't know if the question goes so far as to say that they were responsible for the sham, but just listen to the question, and as far as possible, just try and answer the question. We will deal with commentary at a later stage.
Thank you, Chair.
Yes.
Yes. So we were at the commissioner.
Yes.
Again, guided by the text and not my experience. Section 4181C allows for the master, to, if he can't, to appoint a commissioner. So I don't know, do you, no, let me actually leave it like that. At 4181C allows for the master to appoint a commissioner. And 4183, it's been pointed out to me. So you say Matopo participated in the sham, abated the sham. You say Mr. Portis SC participated, abated. You say Krecha, the commissioner. You say the master participated in the sham. All of them.
Yes, Chairperson, I say that when you go through the documents that relate to this inquiry, so the word sham came from there. There are a number of features that suggest that it was a sham.
Well, you don't have to tell us why. You just state your opinion. That you thought that the inquiry was a sham. Unless you've been asked to explain more. If you are asked to explain why, you can then give us your reason.
Yes.
But you of the view that the whole inquiry was a sham.
Yes.
And whoever participated were all part of the sham, because
Yes.
that's what's being suggested to you now.
Yes.
Yes. Thank you.
Mukhashwa attorneys participated in the sham. Do you stand by your confirmation to the chair's question that whoever participated was
No.
part of the sham?
No, we sent, I'm talking about the people who were behind the setting up, who were leading, who were running things, not that, who were subpoenaing people, who were leading evidence, what came out of it? I mean, I'd like to know what came out of it.
In the light of the provisions of the Companies Act that I've referred you to, that say that it is the master that sets it up and that the master may appoint a commissioner, what is it that you consider to be non-compliant with the Companies Act? And let's restrain ourselves to the Companies Act and not your experience and opinion.
What is it that is not compliant with the Companies Act?
Yes.
No, nothing.
So what made it a sham in the light of the compliance?
I've said what are the features that suggest to me that it is a sham.
Can you attribute the features to Mr. Portes? I want you to attribute, no, but you've said that all the people who participated in the sham. And I'm asking you to attribute the features to each of them. You've said that you found it suspicious that the commissioner was appointed, Mr. Kricha was appointed. You said somewhere. Please attribute as you have, if you can, each of the features to the people I've mentioned.
Just before you carry on, just a minute, sorry.
Where are we getting?
Yes, that's why I want to interrupt. I really don't know how this is all relevant. We are inquiring into really the conduct of Judge Makhubele. This is something that doesn't concern Judge Makhubele, is it?
Chairperson, what we hope to establish with the facts we're getting is that when Mr. Portes comes, his integrity is being impugned, which will go to his credibility in participating in the sham.
When Mr. Boertes comes, we will deal with Mr. Boertes. But let's just deal with what this witness knows. If we go on and ask him of all sorts of things, he will state his opinion. You will ask him to justify his opinion. You will have a different opinion. And we will end up, at the end of the day, of arguing whose opinion we should accept. All we want to know is what happened.
Indeed.
Yes, so let's just stick to that if we can. Thank you.
Chairperson, Mr. Maleka would like to address you.
Chair, and merely is for your guidance, because what we understand your powers and duties to be will be to assess the evidence before you in the light of not only the evidence given, but the credibility of the witnesses who have given that evidence. And if you believe that an examination directed at establishing the lack of credibility of witnesses, we will certainly take guidance from you. But you have witnesses here who have come to make very serious and scurrilous allegations about one of your colleagues. And we think that it is important that you should allow examination of those witnesses in order to test the very version they give in support of those scurrilous allegations. But if you believe it is not, we will certainly take guidance from you.
Yes, thank you. What I believe is this. We are concerned, by and large, with the conduct of Judge Makhubele. Sometimes it is necessary to go off the topic somehow, but it is unnecessary to spend, well, an inordinate amount of time going into what this witness' opinion was and where he was going with it. I would prefer that we deal with the conduct of this witness in relation to Judge Makhubele. If there is anything that's relevant to that, of course, he may be asked about it. But he's now being asked about his views on an inquiry. I'm not even sure he was at the inquiry. And that's it. He may have all sorts of views of the inquiry, and he may have opinions about people. But that's really irrelevant. Let's just stick to what we are concerned with. Otherwise, we'll be here for a very long time. That's the view I take, but I will deal with it a question at a time.
Chair, we take that guidance,
Yes.
and we would then submit at the end of the day that his views about the nature, status, and credibility of the inquiry is irrelevant, and that in due course, when we argue, taking cue from your guidance, his claims that the inquiry was a sham is something that is totally irrelevant.
Well, thank you very much. That's exactly it. So we're going on down this long road about the inquiry, and whatever his views is, on any questions about it, but at the end of the day, as you've correctly pointed out, Advocate Maleka, is really irrelevant.
We can go to the transcript, to the evidence.
Yeah, I think it's 4. It's 4. Yeah. Chairperson, I've noticed that it's 4 o'clock, or at least 3 minutes before 4.
Yes, indeed it is.
Yes.
So we will then take the adjournment for the day, and we will start tomorrow at 10, just to get some clarity. Again, I understand some of us have to drive long distances, so we will sit from 10 to 1 o'clock tomorrow. Thank you.
Mandated.
We will adjourn for the day.